Good evening, everybody. Welcome to the Historic Preservation Commission meeting this August 12th. My name is Joan Keston. I'm the Vice Chairman of the Commission, acting tonight for this meeting as Chairman. Hearings before the Historic Preservation Commission are quasi-judicial in nature. This is a design review process to determine if the proposed project is congruous with the special character of the historic district or landmark. Decisions of the Commission are based on the record of these proceedings, the Wilmington Design Standards for Historic Districts and Landmarks, and the Secretary of the Interior Standards for Rehabilitation. Evidence submitted to the Commission for review becomes part of the record. Appeals of Commission decisions are to the Wilmington Board of Adjustment and then to the Superior Court and are based on the record. Appeals must be filed within 30 days of the date of the Commission's action. Evidence is received during the evidentiary hearing portion of an agenda item. Those who want to address the Commission are sworn as witnesses to present material and substantial evidence to the Commission. The Chair recognizes those who want to submit such evidence during the evidentiary hearing. Evidence should be directed to the Commission. To ensure that evidence is properly recorded, please come to the podium in the hall to address the Commission. State your name and address and speak clearly. A brief reminder that members of the HPC are approved by and serve at the pleasure of the City Council. Our charge is with respect to the protection and preservation of properties in the city's designated historic district. We are held to the standards of the Wilmington Design Standards for Historic Districts and Landmarks and per applicable North Carolina state law to determine if exterior changes are congruous with the special character of the city's historic districts. It is important that we deliberate the merits of each request in a manner that provides a record as to the basis for our decisions. Please remember that our deliberations should be centered on how a project meets the design standards and whether the proposed change is congruous or is not congruous. Commissioners, if you have received or been aware of any outside evidence related to any of the matters, please recuse yourself. At this time, I would like to request that you'll turn your cell phones off or to silent mode. I would also like to introduce members here this evening. Ivy Freitag is the Preservation Planner. Melissa Huffman is the Assistant City Attorney. Christine Hughes is the Senior Planner. Amy Bradshaw is the Planning Coordinator. Is that everybody that's here tonight? At this time, if anyone wishes to speak, will they please raise to be sworn in, stand to be sworn in?
If everyone could please stand and raise your right hand if you intend to speak this evening. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you.
There has been a request that our election of a new chairman be postponed till the end of the meeting. Does anyone object to that? So we'll leave that go till after the applicant process. Amy, Ivy?
We're going to approve the minutes.
Oh, I'm sorry. I need to introduce everybody. Kathy, could you please introduce yourself? State your name.
Stephen Sulky. Christopher Yermel.
Ashley Wilson.
Ron Wilson.
Michael Smith.
Marianne Kaiser.
I can't get onto this.
Okay. We need a motion to accept the minutes from last month's meeting. I just had that one correction, Amy.
Which I corrected, yes.
Okay.
Was that the first paragraph about Mr. Romero's name in
Yes.
the minutes? Yeah. I'd like to also have the closing my comments. I believe that it was beyond the resolution that I would present tonight, also that I would be asking to present again tonight, if that could be reviewed, the audio reviewed and clarified at the ending. The last paragraph, when I spoke and said that I would be approaching.
I'm sorry, I'm having a hard time hearing you. Could you speak into the microphone?
When I spoke, I think in closing, I said not only would I be pursuing a resolution to address this, but that I would be further addressing the issue at the August meeting. If that could be reviewed by audio and included in the minutes, I would thank you.
have to vote. Vote as amended.
Oh, does anyone have a motion?
Make a motion that we approve the minutes from last month?
As
Second,
amended.
anyone? All in favor?
Aye. Aye.
Minutes are passed.
I'm going to, if this is agenda item 1, I'm going to recuse myself from this.
The subject building was built circa 1952, originally for the St. Thomas Preschool. It is a non-contributing resource due to its age. The property is located at 117 South 2nd Street and is within the HD, the Historic District. In this district, alterations to all facades of a building and site are subject to design review, regardless of whether they can be seen from the public right-of-way. The application before you today is for a waiver of the 365-day stay of demolition and approval to demolish the existing brick building on the property. The applicant has submitted engineering reports outlining a range of issues with the building, including extensive repairs required to the building envelope to control water infiltration. On the screen, you'll see just some of the photographs taken by staff on May 21st. The applicant states the building is beyond what can be reasonably salvaged, that it has structural failures in load-bearing walls and substantial deterioration in the brick veneer on all 4 elevations. Repairs would require the removal of more than 40% of the brick facade along with portions of the concrete masonry structural walls. On the screen are photographs taken by staff, but the applicant did submit extensive photographs with their application to help demonstrate the current state of the building. Here are a few photos to show how the building has evolved over time. Significant modifications were made to the building in 2002, including window configurations, replacement windows, brick infill, and the addition of brick arches and wood trellises. The design standards recommend an evaluation of the historic and architectural significance of the building and the impact of the proposed demolition on the overall character of the district. A delay in demolition is only recommended for historically significant buildings that contribute to the overall aesthetic character of the historic district. With that, we'd like to enter the staff report into the record for tonight's proceedings. And in addition to that, I would like to add one quick correction to the staff report regarding the Sanborn maps on page 2 under the property description. Some of the map references were incorrect, and I'd like to correct those now. According to the Sanborn fire insurance maps from 1884 to 1915, a 2.5-story dwelling was located on the northwest corner of the lot, and a 1.5-story dwelling was set back towards the rear of the lot. By 1973, the 2 dwellings had been removed and the subject building was constructed. Thank you very much.
Any questions for staff? No questions? Okay. Would the applicant like to come and present? Please state your name and address.
Good evening, I'm Jonah Dicker. I'm an owner's rep for Dock and Second. My address is 901 Nut Street, Wilmington. I also have some associates with me. I've got Bruce Bowman from Bowman, Murray, and Hemingway Architects, as well as our legal counsel, Amy Wooten from Warden Smith. I've got a supplementary photo set for you guys. While that's being handed out, I'll give you a brief rundown on how we've ended up here this evening. Dock and Second purchased the property in roughly 2017. They commenced a major remodel that was rather expensive. The Commencement of that project started in 2019. We had substantial completion on that remodel in early 2020. As soon as we were on the tail end of the construction, it became apparent that we had microbial growth on the surfaces of the newly installed materials. All of the wallpaper, the beadboard, carpeting, all started showing signs of microbial growth. At that time, COVID hit, delayed our process of trying to investigate what was happening until fall of 2020. In 2020, I came out here and we assembled a new team of local preservation engineers and architects that would assist us in trying to define what the scope of the problem was with the building. By December of 2020, we had pretty significant evidence that we had challenges with the building envelope, as well as the existing mechanical and new mechanical that had recently been installed. If you look at that first sheet there, there's no one particular picture that needs any special interest, but you'll see that we had very substantial microbial growth all over the building. This was before we had an opportunity to even open it up for guest use. In areas where you see just sheetrock, those areas were completely covered in brand new beadboard that had just been installed. So we ended up investigating, removing that, and found microbial growth. You can see the extent of it. It completely overtook the entire building and was, without any objectivity to be questioned, it was not a safe building for people to inhabit. So we hired SKA engineers. They came out and started to investigate what was happening with the overall envelope. We received a file from SKA by March 2021, and they had a thorough analysis of the fact that we had some pretty substantial envelope issues that needed to be addressed. We were fully committed at that point to take out what had already been put in and then remodel the remodel, if you will. If you look at the picture in the upper left, you'll see that all of the mortar is very, very dark. That is all microbial growth. That is indicative of long-term saturation. And so the condition of the mortar on the exterior of the building was suspect to begin with. As you look to the picture on the right of that, SKA had called out several significant fractures that are in the mortar throughout the entire surface of this veneer. And I've highlighted in the yellow for you the stretcher course. We've got those stretcher courses every 2 feet on all elevations. Those tie the veneer brick to the structure, which is CMU behind it. SKA found evidence throughout the building that those stretcher courses have fractured, and the veneer of that brick is no longer physically attached in a significant way to the structure behind it. As you go to the center image on the top, you can see we did some investigative work where we found fractured stretcher courses, and in addition to that, all of the steel lintels on all of the fenestrations on the building have significantly deteriorated. In the image on the far right, you'll see the condition of that steel. We were still at this point committed to salvaging this building. We pursued options to figure out how we can re-adhere the brick veneer to the structure behind it. We brought in a specialty company called Prosoco, and they manufacture a anchoring system that would allow us to retroactively affix that to the CMU structure behind it. They came out and did some testing for us. You can also see in the image in the lower left that they presented for us, the condition of that masonry was so poor that there's actually vegetative growth coming out of the side of the building, and it was in very, very poor shape at that time. They were able to determine that we could use their anchoring system to reaffix the brick. With that, our hard cost just on the anchors alone was going to exceed $30,000 before we even started getting into the labor and the feasibility of doing that process. You'll notice in the lower right, we've got what looks like a window affixed to the side of the building. That was a test run by SKA. It's a standardized test that emulates wind loads and water penetration to see how much water gets absorbed by that masonry in typical rain conditions. So they run water through there and pressurize it. It's a standardized test. It's supposed to run for 5 hours. They had to stop the test after 50 minutes because there was so much water pouring through the inside of that wall that they determined it was no longer sufficient to even have to study it. Through the course of those investigations, SKA came up with a protocol for us to follow to salvage the building. It was going to involve those Prosecco anchors. It was also going to involve a vapor permeable coating that we would have to cover the entire building with to help to prevent further moisture penetration. In addition to that, as I started to investigate the fenestrations around the windows and the exterior, you'll see on these images here on all 4 elevations, we've got areas in red. Those areas in red are areas where the steel lintels were so deteriorated that they had to be replaced, and the entire facade on those sections needed to be completely removed. We would also have to rebuild the CMU structure behind it to get satisfactory structural integrity in there. And then we would have to install an entirely new brick facade in those areas as well. As a total surface area, it's right around 40% of the entire building would basically have to be removed and then rebuilt again. In the areas where you see the light yellow, those are areas to be included with the red. The entire surface area of the building was going to require the vapor permeable coating as well. These were considerations at this point that started to exceed any realistic sort of financial feasibility to it. When we were looking at basically having to rebuild 40% of the envelope on the structure, including a new roof, not including the roof, it became a question of the viability of whether or not this even made financial sense any longer. We determined at this point that there was no sense in chasing this down any further. It was just far too costly for any potential use of this building. We also had some challenges on the south wall. If you look in the upper left corner there, this is a shot that's on the interior of the building. And we have soil elevations on the outside that are approximately 40 inches above the finished flooring here. This is the same area from the outside. You can see that the proximity to the neighbor's wall is very, very close, and we don't have a viable way to get into this area and excavate to be able to put in proper vapor barriers and water barriers to prevent water from the osmotic pressure pushing into the building and causing damage in here. Over the years, there's been so much moisture that the furring in here is actually rotted from the excessive moisture. And we don't have a viable way to get in and actually remedy this condition due to the nature that it's so close to the neighbor's yard. As we started to investigate and we were pursuing the remedies for the envelope, we also became aware of some very significant structural challenges with the building that tipped us to the point where we could no longer justify investing anything further. There's many load-bearing walls in the entire structure that are missing sections from previous remodels, we suspect in the early 2000s, and they had never been taken care of, and they're simply covered up. As you look through here, we've got sections where somebody stuck a 4x4 to support a load-bearing wall. You can see there's fractures above and below those areas, and this is indicative of how this was handled previously. This area right here, which is an entryway, I put some dashed lines in here that give you an indication of what those courses should have looked like. Granted, there's a little bit of distortion from the photograph, but you walk in there, it's clear as day. As you look from left to right, this is settled in excess of 1.5 inches. And we've got fractures in the load-bearing wall here. This header has settled and has been significantly compromised as well. As we continue to go through the entire northwest corridor of this building, which is roughly 1/4 of the building itself, it became evident that this has been settling and moving over time. And if you look right here, in this particular room, we have a massive fracture in the wall. The size of that gap right there is greater than 2 inches, and you can see clear through it. Again, this is a load-bearing wall sitting on a primary foundation that has failed. We went in, excavated. This is the outside of this image right here. We excavated out to investigate the footing, which has been compromised. There's been significant settling in there. If you go out and you look from the street on this retaining wall here, you'll find a very clearly defined fracture that has broken through the CMU structure as well as the brick veneer. It's been telegraphed all the way through the veneer. You'll also notice above the doors here, we have significant fractures where this entire section of the building to the left has started to settle. This is a close-up of the fractures that I'm referring to right here. As you go further to the north on the building, you'll see that there are, I believe there are 5 of these anchors that were put in, we presume, sometime around 2000. And those were sort of a retroactive fix, we believe, that were sort of to function as a post-tension system to help stabilize that section of the building. It has not worked. We have evidence on this wall here where they patched the crack at a time when it was about 1/4 inch. And all along the edge here, you can see where the adhesive they used and the caulking has now separated and moved with the wall as it has been settling. We also did core sampling to find out what was happening underneath the foundation. This is taken in this room right here, which is above these anchors. And we found that the grade below the foundation has settled about roughly 4 inches. And this would all require ramjacking and figuring out a way to stabilize this entire wall and this entire room. That room also has roof joists that have rotten all the way through and are no longer structurally sound, and those are integral in helping to stabilize that wall, and those no longer exist. And if you go out to the alley and you look at this corner, this upper corner here has now kicked out of plumb, and it's, I'm going to call it roughly 3 inches out. There's evidence all the way around the building that this entire section is settling and continues to move in spite of previous efforts to try and stabilize it. And this is on the alley here. This is the CMU retaining wall, and that's been fractured as well. Further evidence that it's continuing to move. In summary, we had every effort made to try and salvage this. We've invested over $2 million to date simply on construction of this building. That doesn't include all of our experts that have come in to give their assessments, and that doesn't include purchase price of the property. That's simply $2 million towards the efforts to use this building as it was intended initially. We are no longer able to continue to invest into this in light of the fact that there are such structural deficiencies that prevent us from justifying any further cost on this.
Thank you.
Thank you.
I just have a question out of curiosity. When you purchased this, did you have an inspection report done?
Yes.
And none of this showed up?
I can't speak to that.
Any questions?
I wanted to thank the applicant for a very thorough presentation. It's difficult to understand this sometimes, and your presentation is excellent, and thank you for going through this process for us. Yeah.
It's my pleasure. I appreciate your time. Thank you all.
Sure. Anyone else?
Thank you, Madam Chair. and Commissioners. My name is Bruce Bowman. I'm working with Jonah and the Rive Hotel folks to, well, initially to preserve the building, and I am with Bowman Murray Hemingway Architects, 514 Market Street, and am a preservation specialist. Some of those projects include Governor Dudley Mansion, the oldest building in Wilmington, Mitchell Anderson House, and the most recently 226 North Front Street, the Common Desk Building. And the latter two were really an exercise in how to hold on to the brick and how to keep the brick holding on to each other, because the walls were crooked and layers of dust instead of mortar, and you know, some projects warrant the extra heroic effort to bring to bear these kinds of technologies, but oftentimes they don't really work out very well. Retrofit anchors, you know, I give them about on a good day, a 60% efficacy of hanging on to the brick. So, you know, as I look at the staff report, oh, and interesting, on your view, the upper right corner, which is also, I think, found on page 63 of the staff report in a better quality image, the gray that you see in the middle was an old chalkboard from the preschool. That's where the 2-inch gap is. The yellow above that shows that they filled in that 2-inch gap when it was only 1 inch, and now it's 1 inch of fill and 2 inches of gap, and as it goes through the chalkboard, you can see that. So that tells you that every 30 years or so, you get about an inch of fatigue outward. It also tells you that the roof structure is separating from the bearing walls or buckling, all of which are just really catastrophic to try to overcome. And then as I look at IV's standards as they apply to demolition, I think you'd agree that very few of those, if any, apply. Of course, the owner is willing to work with salvage items with the historic foundation. That's not a problem, but I think all that's there are maybe a few metal rails that are worthy of any kind of salvage. And I think for the record, Jonah, there are 4 conditions with the staff report, and I think you're in agreement with all 4 of those conditions. Okay, thank you. And so we all came prepared to make this project work. It's just not worth it. And and the owner is so financially fatigued at this point, they can't even really put it back in service in its current instantiation. And I think it could really be much better than what it is now, which is a dramatically failing, non-contributing building, and with really little or no architectural value, in my view, as a professional. So with that, I'll take any questions if there are any.
I think not. Thank you. Very good.
Okay, thank you.
Anybody else from the applicant? We'll now open the evidentiary proceeding. Anyone who wishes to submit evidence is asked to come to the podium. Please state your name and address and present your evidence. Anyone? Have you been sworn in? Okay.
Good evening, Madam Chairman and Commission. I'm Catherine Finland at 121 South 2nd Street. I am the neighbor whose retaining wall was shown in these photographs. I'm on the corner of Orange and 2nd Street. I'd like to thank you for the opportunity to speak and also for your continuous efforts on behalf of the Historic District of Wilmington and the preservation of our community's culture, architecture, and history. Thank you also to the staff for your continued dedication. And I want to extend empathy to the applicant, my neighbor, who is learning the hard way how we in the Historic District buy our properties 3 times. The first time when we acquire, the second time when we rehabilitate them, and the third time when we continuously upkeep them through time. I share about 100 feet of adjoining property line with the applicant, and I have some photographs I would like to enter into evidence. Amy, do you have them available on for the screen? Okay, I have some photographs to share with you, but I'll speak while they're bringing that up to the screen. All of the adjoining properties to the parcel at 117 South 2nd are zoned historic district residences. However, my property is the only one adjacent to the structure in question this evening, and we share my north wall and their south wall. The preschool building was constructed 100 years after my home was built. My family calls the Ballard Bellamy house our home. It was constructed in 1844. It predates both the Bellamy Mansion and the Latimer House. As you can imagine, construction to and proposed demolition of the structure at 117 will directly impact our property, our home, our lot, and quality of life. You can see in the photos here, and I apologize, I don't have prints, but they are on the screen here for you. The first photograph is the front of our home, and you can see the 117 structure in the background. It's about roughly between 25 and 30 foot that separate us, and also important to note here in the topography, our house sits above in grade, and the retaining wall, which would be impacted by any construction, demolition, or rebuilding on that lot, could potentially affect our foundation in our home, including vibration and or settling of the dirt or resettling. This is how close we are. It's mere inches. There is a ballast wall at the very bottom that dates probably from the building of our house, and then you see a brick veneer that's been added to the top as the brick fencing was added to the surrounding of our home. This is the front corner where our buildings meet. So this is 2nd Street, where our buildings both face 2nd and adjoin each other. You can see where they are putting an AC drain line outside the wall into the void space. This is the view of the building from my side yard, and this is further back in the lot, looking down the length of the wall. And this is how close we are between the rear of their building and our shed on property, and the view from our porch. This is also a view from our backyard into the parking lot of 117 South 2nd. I'm hopeful that the Commission does not bring this particular request to a vote before plans are brought forth detailing elevations for the future proposals. Our family, and I don't believe any other neighbors, have been approached by the applicant in terms of a community meeting or any discussion about what's planned here, or even discussion about the proposed demolition. Cost to repair, as we know, in the historic district is usually not typically a factor, as it's known that historic buildings face structural and cosmetic needs over time, and the repair of these always far outweigh the lesser cost to build anew. It's my further hope, and I would like to appeal to the HPC, that should you approve the applicant's demolition request in this COA, that some provisions are put in place to protect the surrounding structures, which are contributing to the historic district and are our family's main residences and investments. The first would be, the applicant has made no mention in this application regarding what provisions they're going to put in place for safety of our homes. It's my understanding that in downtown projects, and perhaps the architect has experience with this, that special inspections and geoengineering consultant groups are brought in to place vibration monitors for active monitoring for any type of vibration that may impact surrounding structures. I think that a requirement that this be provided by the applicant to the neighbors in form of reimbursement for such invoices would be an important factor. In talking to some of these companies, I've learned that pre- and post-inspections for surrounding properties are also part of this process. So it's my hope that that would be a consideration. It would also be my hope that the applicant not be allowed to continue with any such demolition until the neighbors are given notice. Again, we have not been given any contact directly from the applicant other than the letter we received about this meeting tonight. So it would be rather shocking to see this building come down without knowledge of what date that would take place, and certainly further discussion about protection for our structures in form of pre and post inspections and active vibration monitoring. Questions I would ask of the client, had they had a community meeting, would have been, what's your proposed plan for 117? How does this plan meet with the requirements of the SUP in place for this property? And as the SUP was granted, given a site plan that has a single front and rear entrance, is this your plan to maintain the site plan as it was in the SUP for operating as a guest lodge on the property? I think that's all I have tonight. I have reached out to the client. Both founders of the hotel and the current representative tonight have my personal cell phone and address, and I look forward to having further discussion, and I hope that HPC will allow us some time to have those discussions and work some things out. Thank you so much.
Thank you.
Good evening, members of the Commission. I'd like to introduce myself. My name is Russ Bryan. I'm an attorney with the law firm of Grady Richardson, and our firm represents Bruce and Sonia Carell, who are here tonight, and they will be speaking at some point after me as well on this application. Something that has not been brought up to the Commission to this point is whether or not this Commission tonight has the jurisdiction to make this decision. And I say yet. I think this Commission does have the jurisdiction, obviously, to review this application, but we don't believe that you have that jurisdiction quite yet, and we ask you that you deny the application. And I guess those have been, yeah, if you wouldn't mind handing those out. There was a couple of years ago when the SUP was granted for this property, the Carells who live behind this were concerned about some aspects of it and unable to, and y'all may be very familiar with this, but a lawsuit was brought with the city to correct those and the applicant. And so we've got three parties here, the applicant, the city of Wilmington, and the Carells, and without all the history of it, in essence, rather than going through the full trial, they had a settlement agreement, and you're getting a copy of that right now. You'll get a settlement agreement, a consent order, a judicial consent order, and a revised city ordinance signed by the mayor. And what that does is establishes jurisdiction within the Superior Court of New Hanover County. And if everybody's got that, why don't we turn to the blue tab? I'm going to jump around in this just a little bit. But there's a blue tab in there, and that marks the beginning of the consent order. And I don't have a lot of space here, but give me one moment so I can follow right along. And if you look at the parties, I just want you to confirm that we've got the applicant involved, the city of Wilmington, and the Carells, and that this order, which was filed in January of 2020, not very long ago, does deal specifically with 117 South 2nd Street. If you turn to page 4 on that order and look at paragraph 3, this is the signature line where the Honorable R. Kent Harrell has signed. But in his order, he establishes that the findings of fact, conclusions of law, and terms of this consent order are binding upon the parties and their successors and assigns. In other words, if anybody sold their property, it would still apply, and may be amended or modified only by order of this court or written agreement signed by all parties. That settlement agreement goes into great detail about what the applicant can do with the property. And it also caused the city council to file an amended ordinance, which is the last couple of pages of your packet there, and establish very clearly in the recitals. I'm looking at the ordinance on the next to the last page, but that the Wilmington City Council desires to fully comply and consent with the judgment and the order. So we're in a situation where, as the previous speaker said, that the applicant has not reached out to other neighbors to explain anything about what the future may look like. We've, with all empathy as well for the condition of the building, and I've known Bruce Bowman a long time, and it's unfortunate that this building has gotten to this point, or allowed to get to that point, despite the amount of funds that have been put in there. But we're in a situation where we don't think this commission is allowed at this point to render a decision on whether or not this building can be demolished. The reason that is that this settlement agreement, this consent order, is attached to this property and this building. And destroying that building eviscerates a large portion of this order, which currently controls. Now, it does allow for the parties to get together, understand what's happening, and agree. And I think at that point, this commission would be in the position to, of course, approve any kind of request for demolition or something of the sort. The other alternative is a judicial order that says, you know, yeah, we've reviewed this. We are the only people that can amend and modify this. And it is okay for this commission to review this and approve or deny the application. So and I think that gets to the heart of where we are. We don't know what's happening with the future of it. They have claimed to us in a brief discussion just 2 days ago that they have no idea what they want to do with this property, that there are no plans at this time. And that's fine, but it also means that there's no need to rush this process. There's nothing that I heard so far this evening or read that suggests that the 365-day stay period should actually be dismissed, I guess is the for lack of a better word. And our clients are reasonable people. They hope to have a dialogue and figure out what's going on, but they haven't had any opportunity to do that. We're asking the commission for some time to do that. In addition, I believe you were given ordinance, section 18-111. It's entitled Conflict with Other Laws, Decisions by City Council. I'm not sure if y'all got that single piece of paper. Yeah, it's just slightly highlighted there, subsection B. And this just speaks to the fact that we believe that the commission is currently barred because the City Council, in adopting the amended ordinance, has already spoken to what can and can't happen, and as I read before, fully support the judicial order that's in place. So I think when you have a situation where the board or the commission's decision might conflict with something that the City Council does, section 18-111 subsection B, I think clearly says that City Council is going to take precedence over that. And there's the other awkward aspect of that this commission is an extension of the city, a wholly owned subsidiary, if you will, which arguably makes you a party to this consent agreement and party to the consent order and settlement agreement. I don't know that we're all going to sort that out entirely here tonight, but I believe that we firmly believe that that's the case here. And as a result, one party of the settlement agreement can't decide what other parties are able to do, which is why the court is in the position of having to be the only ones to modify or amend that order. And then it gets to where everything's cleared up, and I think it comes before this commission appropriately. I don't think this commission should be in the position either of carrying the torch for this applicant in any way. When this order was done and the settlement agreement was made, there was no contemplation for the demolition of the building, which we heard tonight. And there was some discussion about some lighting and so forth out there, and I know that one of the reasons that we're here is that there was an argument, that on the last paragraph that this commission has the right to hear all exterior lighting and changes to the exterior of the building, requiring a certificate of appropriateness. And I was talking to my client, and they made it clear that came up when they were concerned that a large hotel chain may buy the property and have a great deal of lighting that would affect their property. And so that paragraph was put in there by the city and by the applicant. And but to have a change to the exterior is, having an exterior and something before the exterior and something after the exterior that looks different. It's changed. They're contemplating removing the exterior altogether. You won't find anything in this settlement agreement or this consent order that allows for demolition. And that's why we think that this is not properly before this board at this time. So if, demolition creates an irreversible loss of resources. That's the first line of the demolition paragraph of your of the requirements to do so. And we're asking you to, at the very least, if you feel that you do have jurisdiction, if you do think that you're in the better position right now to rule on this applicant, that we're asking you to keep the 1-year stay in place. And of all those demolition standards, I did not see anything about a court order and settlement agreements, but there should be that. That's obvious that although that's not a part of it, that's a very important reality in this case. I haven't heard if this is stayed for any reason where the applicants would be harmed. Obviously, nobody's in that building. It's unoccupied. The mold, some of those issues, no one's going to be harmed by some or any delay in this demolition. And we're hoping that we have the opportunity to have some dialogue. And Ms. Carroll is going to speak to some of the historical significance. But if we're still inclined to grant the applicant, we're asking for any delay so my clients can have some dialogue or assert some of their legal rights under this binding order, even tabling it. But a 9-month, 6-month stay, if you do happen to approve it, we don't see that that's going to be harmful to the applicant, as they have no plans. They've assured us they have no plans at this time. So in conclusion, please consider that the terms of this settlement agreement, that they do apply to this property and are binding on this property until such time as that they are waived by a judge or the parties involved. And at that point in time, it might be appropriate to be in front of this commission to seek the demolition once we know what's going to happen in the future. Any questions for me at this time? I'm sorry?
Tell me again who you're representing.
The Carrells. They're parties to this agreement, and they live behind the subject property.
And the agreement was for the future use of the property as a guest house with parking, and it seems to discuss garbage collection and a variety of other things.
Yes.
And so how are they harmed if this building comes down? They don't have any interest in the building itself, do they?
Right. Well, no, they do not have any interest in the building itself. Obviously, have interest in what happens to the building. But whether or not they're harmed by their eviscerating their legal rights by demolishing a building that is subject to a court order currently.
But doesn't the court order apply to the land, to the address, so whatever building is up, that court order would apply, whether it's this building or a future building?
I believe that's correct as well, but it's our contention that it applies to the building and as well as the land.
I understand that it follows the land. I understand that.
Yes, ma'am.
So to me, I mean, as you said, they have no interest in this particular building. Whatever would be there would be subject to the court order.
We agree with that as well. However, we take it a little bit further and say that that this order specifies what can and can't be done, and demolishing the building that this is subject to is at least an amendment or a modification to the settlement agreement, at least. And in that case, the very first thing we read is that two groups have the option to change that. That is the Superior Court of New Hanover County, or all parties can agree. And that is plain and simple what the order says.
Melissa, do you have anything to add to that or to explain?
Sure. The City Attorney's Office, our position is that demolition was not contemplated when this was created, this settlement agreement. It was not precluded at all by the settlement agreement and the consent order. We do point to the language that the attorney just mentioned about any exterior lighting and changes to the exterior of the building would require a certificate of appropriateness, which is exactly the avenue that the applicant has gone. In our view, demolition of a building is at its most fundamental level is a change to the exterior of the building. We also believe that if the neighbors or the parties to this consent order believed that this was running afoul, if this hearing was running afoul of the consent order, they had the option to go to New Hanover County Superior Court and bring it up there. But what is before you all as a commission is the simple question of the certificate of appropriateness and whether that 365-day stay should be waived. You don't have the statutory right to deny a certificate of appropriateness. You only have the right to delay it up to 365 days. So the gentleman's other discussion points about possibly delaying it for a number of months, that is all within your purview to allow folks to discuss, to get plans together as far as making sure that neighboring properties are protected while this demolition is happening. You know, that is all certainly within your purview. What is not within your purview is what may happen to this property in the future. That is beyond your scope. It's not relevant to the 365-day stay on what the applicants plan on doing in the future.
And if for some reason we waive the 365 days, they could always appeal this?
Yes, they could absolutely appeal this. They could also, to ensure that no quick demolition is done, seek an injunction. There are remedies. And it could be appealed both to Superior Court or to the Board of Adjustment.
Okay, thank you.
Mm-hmm.
If I may speak to that, and respectfully, we disagree about the language on paragraph 15 about exterior changes. That was clearly contemplating lighting at the time they were negotiating that, and changes to the exterior and demolition, in my world, are two completely different things. I think it's a stretch to consider demolition to be a change in exterior when the paragraph talks about exterior lighting. Our concern on behalf of our clients as well with regard to that is that there will be quick demolition. A construction dumpster was delivered today to the property. We're concerned that our 30 days, that if we are in a position to have to appeal this decision for any reason, that that we might not get this filed in time, or that this thing will be demolished before the 30 days. So if the commission would respect our opportunity for the right to appeal, then we would ask for at least some delay in this stay, if you are inclined to grant this demolition tonight, or you feel you do have jurisdiction.
How long would you prefer that there'd be a delay to do what you get together and?
I've kind of started up here and went down to whatever the board thinks is reasonable. We're obviously, our first request is to allow the stay to be in place. There's a 365-day stay for all demolitions for a reason, I presume. It seems to be waived pretty frequently, but Mr. Bowman, if I'm correct, mentioned a project he was involved in and that was mentioned in the report. I think it was 226 Front Street or something like that. And as I read that in the report from staff, that 365-day stay is in place. So it's certainly not unheard of to do that. And again, with no immediate turnaround plan, a long way off from that, I don't see how the applicant's injured in any way. So 9 months, 6 months, I mean, at the very least, 30 days, so we don't lose the ability to file an appeal and the building's gone before the parties have a chance to have any dialogue whatsoever. But to be reasonable with everybody's schedule, you know, I would hope that we'd have a minimum of 2 months of some type of stay, so we could file whatever legal things that we need to file, but also open the door for dialogue, and maybe these parties can get together and everybody can move forward quickly.
Thank you.
Any other questions?
I would like to hear from the applicant again.
I know that the Corrells would like to speak as well, but if we can do it whatever order you prefer.
Why don't we hear the Corrells, and then we'll have the applicant come up after all the evidentiary hearing.
Okay,
Thank you.
Madam Chairman and members of the Commission, thank you for the chance to speak to you this evening. My name is Bruce Carroll, and our property is 120 South 3rd Street, directly behind the subject property. Our rear,
Sir.
I'm sorry?
I'm sorry, could you speak a little bit closer or into the microphone,
sure.
a little bit easier?
I'm sorry.
Thank you.
The rear of our property abuts the property of the subject property. There's a retaining wall between the two. We bought our home approximately 6 years ago with a reasonable expectation, I think, that the city would protect our property and our way of life, our quiet enjoyment of our property. And once we bought that property, we spent literally hundreds of thousands of dollars to renovate it, every surface inside and out. It's literally our dream home, and we plan to retire there and enjoy the city of Wilmington. The city, though, did not protect us as we believed they would, and we were forced to litigate this matter, as Mr. Bryan has explained, to protect our rights and our property from an illegal modification of the SUP. Arrive now wants to violate the agreement that we made with them and demolish the building. And they indicate that it's too expensive to repair. I quote from their application, "It should be recognized that while repairs are academically feasible, they require expenditures that far exceed any real or imagined value for the existing structure." That's Chris Pardo who wrote that. I suppose many of us in the historic district could make the same argument. It's just too expensive, but we haven't. We have spent real dollars renovating, maintaining, and protecting these fabulous historic structures by our own volition. I've been a licensed contractor in North Carolina for 35 years. I hold unlimited general contractor licenses in both North and South Carolina. I've completed over 1,000 projects in the 2 states. Residential construction, residential renovation, commercial construction, commercial renovation. Over 40 of those projects were historic renovations here in Wilmington, in Charleston, and in Atlanta. With that experience, I'm certainly capable of evaluating the information that we've all heard. I read it in advance, and they did a very thorough job of telling us what was wrong with the property. But what I never heard them say was it couldn't be done. I heard how expensive it was going to be and how they didn't want to do it, but no one said it can't be renovated. And we've all walked around Wilmington and we've seen structures with worse conditions than this that have been restored beautifully and kept as a part of the fabric of the community. We argue that the approval of this demolition application is really a betrayal of our rights with the city's agreed upon settlement and consent order, and we urge that you deny the application or at a minimum give us some additional time to reach a resolution with the applicant. And I thank you for your time and attention, and I have a copy of my comments that I'd like to enter into the record.
Thank you.
I have a question. What type of resolution would you be seeking from the client?
We would, I think at a minimum, want the standards and stipulations of the agreement that we had in place to be in effect for whatever it is they plan to do next. But they will not tell us what they plan to do. We have asked, and our counsel has asked, and they've been very vague and just said we don't know.
Yeah, thank you.
Thank you.
Good evening, Madam Chair and Commissioners. I'm Sonia Wall-Carroll, wife of Bruce, owner at 120 South 3rd Street. We're here tonight again to ask for the denial of the application for prior stated reasons, as well as some reasons that I will state. And if you don't find cause to deny it, then a full 365-day stay of the demolition. The reasons that I'm going to set forth, and I have exhibits that I believe support that, or we don't believe that the applicant has met standards, design standards 2, 3, and 8 as set forth on page 105 of the design standards. And we also do not believe that the applicant has followed the requirements set forth in the LDC section 1896A3. And I have some exhibits that I'm going to distribute. They're marked pictures 1 through 8. Picture number 1 is going to be the primary, I guess, representation, because that actually is on the applicant. It shows a fencing structure that's on the applicant property that is interrelated to additional fencing and retaining walls that go all the way around the property on, from this picture, an additional 2 sides, and there are lots of pictures about that, but picture 1 shows the enclosure that is on their property that does not appear to be on the site plan as required in section 1896A3. Also, I would like to ask that the record be corrected. Respectfully, I believe that on the application, under the findings of fact, item 3, I believe it indicates that the zoning for 101, 105, and 109 as CBD HDO, and I believe that 101 is CBD, but I believe that 105 and 109 are CBD CD. And I think that's an important distinction. I think that misconstrues and creates a misperception that all of this is CBD, when in fact CBD CD is a different designation, and I would like for the record to be corrected to reflect that. So now I would like to introduce into evidence exhibits 1 through 8, as well as exhibit 9, 3 pages, which is my written statement. So I think a portion of Design Standard 2 was read earlier relating to the historic and architectural significance of the building. However, a second part of that Design Standard 2 indicates that an evaluation should be done of the impact of the proposed demolition on the overall character of the historic district and adjacent buildings. So as I've spoken to, there is fencing structure, which I will get to the section of the LDC that requires a site plan that shows all structures on the property. So that fencing structure that is on Exhibit 1 is actually, again, interconnected to multiple layers of other fencing and retaining walls. At the rear of our property, there's a retaining wall that's approximately 15 to 16 feet tall that supports our rear parking areas and rear gardens. So I don't know how we can proceed with an application when the design standards very clearly call for an evaluation of the impact on adjacent buildings. In particular, our home, which was built in 1851, a historic structure. And again, if you look at those additional pictures from Exhibit 1, Exhibit 2 shows a close-up of that. 3 shows its connection to the other fencing and retaining walls. Design Standard 3 indicates a delay in demolition is recommended for historically significant structures that contribute to the overall aesthetic character of the designated historic districts. I understand there's been a determination that it's not a contributing structure, but we would still argue that it's historically significant, and your own design standard, Standard 3, indicates a delay in demolition is recommended. And Design Standard 8 goes back and indicates, during demolition, ensure the safety of any adjacent properties. So I don't know how we can really talk about ensuring the safety of adjacent properties when this information hasn't been spoken to at all in the application. A portion of it's not on the site plan, which I think the LDC requires. So how can there be appropriate protection for that when it's not, when it hasn't been included in the application at all and hasn't been spoken to at all by the applicant? When we bought our home 6 years ago, over 6 years ago, we fell in love with the house and our neighbors at that time and the city of Wilmington. Our home, and this is a unique, I think, block in the district because while this building that we reference is zoned HD with an SUP on it, all of the other properties that adjoin it are zoned HDR. And so McLean Alley separates it from that CBD, CD conditional district zoning. But in doing a little bit of research about my home recently, I found out that one of the original occupants was a first-generation immigrant from Puerto Rico. Once Edward Savage, I think some of his family had ownership of some of the land, and he married Marquesa Maria Teresa Fernandez Savage. And also in doing that so that was about my home in particular, but also in doing this research, I discovered that this building was actually constructed in 1952, I believe, as St. Thomas Parochial School, which is, I believe, to my understanding from the research I've done, was built specifically to teach and educate African-American children. And so much of that block, including St. Thomas Church, which is now Preservation Hall, and so many of the other surrounding buildings were part of that legacy of reaching out to the African-American community. So I think that's important too when we're talking about the historical significance of this building as a structure. And as has been stated, the applicant hasn't, so I believe our attorneys reached out and requested what are the future intentions. So if they haven't expressed their intentions to us or to anyone, I think my neighbors, what's the haste? And why then, why does the 365 days stay of demolition, why does that need to be lifted if they don't know what they want to do with it? It seems like it should be the reverse. We should err on the side of protecting the surrounding historic properties and us as adjoining landowners and our property rights. I'll go now to section 1896A3, and this is in my notes, which will be submitted into the record. Section 1896A3, you guys, I'm sure, are probably familiar with this, the requirements and procedures for a certificate of appropriateness, which I believe applies in this situation. A3 says a site plan drawn to scale showing the location of existing and proposed structures. Under the City of Wilmington LDC definitions, structures defined as anything constructed or erected with a fixed location on the ground or attached to something having a fixed location on the ground. So we believe that fencing structure that you see in Exhibit 1 is interconnected to multiple other layers of fences and retaining walls, including going down the side of my neighbor's property, intersecting with our property, and then continuing down as my neighbor, Catherine Finland, expressed. So we don't feel like that requirement has been met. We think it's not just relevant, but that it's a critical and substantial part of information that is important to it, and that the application's deficient without it. So we very respectfully request that you deny the application, and that if you see cause to approve it, that you put in place the full 365-day stay of demolition so that we can protect ourselves, our property, and have the right to do that, and also to have a full and better understanding of what, how our properties will all be impacted from the demolition. Thank you very much.
Thank you. Anyone else wanting to present evidence? Will the applicant come forward again? We have some questions.
To address a few of these concerns, new plans for this property are not relevant to the conversation tonight. There's no obligation on our part to have to express that. More specifically, the use of this property will take time to develop. We need to sort of articulate and figure out what it is that we want to use it for, but it is not germane to tonight's conversation, and we have no obligations to have to define that at this point. There are considerations in regards to retaining walls adjacent to our property. The south wall that I showed you, if you look closely in the images I provided, the neighbor's wall is failing. It is 100% on her side of the property line. It is her obligation to resolve. Now, if I come in and I tear out the wall of our building, I guarantee we will subvert her footing. I'm willing to spend time and effort to find a solution. We've talked about it with our engineers to make sure that the removal of the structure does not impact the adjacent wall, but she does have an obligation to take care of her own wall, and we're not obligated to do so on her behalf. Now, if you look at the image that's on the screen right now, we are simply going to be taking the structure off of the slab. In the time that we're asking for, the building is not structurally sound. It is unhealthy for anybody to go in there at this point. So there is cause for concern as to leaving this building in place. If we tear out the retaining walls that you see that are on the right and left of those stairs, we're asking for a substantial sort of endeavor that I don't think anybody is prepared for at this point. Our concern is the structure itself above that. And in anticipation of trying to limit the impact on the neighbors and to resolve issues with the adjacent walls, we will be taking just the structure from the slab up. Those retaining walls to the right and to the left of the staircase will remain in place until the ultimate usage of the property has been defined. And at that time, the scope of use on that property will be subject to purview from the City Council, and we'll go through the appropriate steps. But as it stands, we don't have defined use for it, nor do we need to. But we are concerned about people's health, and we are concerned about people's safety, and there is a need to remove this structure.
Would you be willing to meet with the neighbors and work through some of the issues they raised? And I'm not saying that you're responsible for their things, but in order of cooperation so that we're protecting these historic homes.
And that just a little bit lower. We're certainly happy to...
Could you state your name, please?
Oh, I'm sorry. It's Amy Wooten, Warden Smith, counsel for the applicant. And thank you all for your time and the opportunity to speak with you this evening. My client is certainly happy to consider and just have discussions with the neighboring properties about their concerns with respect to the future use of the property and the impact to their property. The future use, as Melissa Huffman discussed, is not before the commission this evening, and there will be an avenue and an opportunity for all landowners that have an interest in standing to raise their interest before the commission when there's an application pending before it for a future use at that time.
I was questioning the process of demolition, not the future use.
Oh, I apologize. Yes, the client would be willing to have those discussions. We don't believe that those discussions warrant a 365 delay or that period of time is a reasonable period of time for those discussions to happen. This hearing was supposed to happen last month, and the predicate reason for that was to give the Carrolls an opportunity to have discussions and to move forward with pursuing what they believe to be their rights under the consent order. They did not file anything with the Superior Court at that time, nor did they move forward with seeking any other avenue of legal relief in the court system. So we do have some concerns about providing a period of time that would match a year for this health and safety reasons, and also because we don't believe that amount of time is necessary in order for those kinds of conversations to be had. So we would, if the commission were inclined to grant some form of a stay, would ask that a very minimal period of stay be put in place that would allow for some discussions, but not be predicated on my client meeting the every need or wish or grant or desire of the adjoining property owners. And given the condition of the property, the health and safety problems that it poses, we do want to make sure there's a striking of that balance there.
Thank you.
And I would just add and reiterate briefly, if I may, that we are in agreement with the City Council, the City Attorney's Office on the position of the application to the Commission's jurisdiction of the settlement agreement and consent order. It does not apply, as Ms. Huffman noted, your statutory right. There's not a statutory right to deny the certificate of appropriateness that's pending before you, just the opportunity to delay. And our client is very much in disagreement with the interpretation of the settlement agreement and consent order. I know that their counsel made reference to the terminology and the language related to lighting. I'm sure you all can appreciate that words have meaning, and if we're looking at that provision, it does say exterior lighting and exterior changes, and there's nowhere in that document where it contemplates or discusses an exclusive use of that property in perpetuity for guest lodging purposes. So would just note that objection for the record, and happy to take any other questions that the Commission may have this evening.
I have one. What is the proposed method of demolition? Giant hydraulic excavators or something not shaking the earth? I mean, I'm curious about that because I do want to protect surrounding properties.
I can maybe take that if you like. Yeah, I think Bruce can speak to this, but also there is a sensitivity to the old structures surrounding this property. If we come in and we're too aggressive, yes, there is an opportunity to cause
Could you
problems.
move a little closer to the mic, please?
Yes.
Very hard.
It's not our intent to create issues, but our objective is to always limit exposure and risks for all parties involved. We will be using a very controlled demolition where we'll be coming in with a large excavator with a claw that will take it section by section. In areas where we have the adjacent retaining wall, we've already discussed that the south wall of the building will actually stay in place for the time being, but we will come in beforehand and we will be cutting that wall with large saws to make sure that we can come in and just remove sections above 4 feet so that the bottom 3 feet stay in place until a solution can be found that does not affect the neighbor's property until she has an opportunity to figure out how she's going to fix her wall.
this giant excavator is going to be on the property or working off the street, or
No,
where's-
we have a large parking lot in the back, and the building is...
back there. Okay, I
The
saw
building is accessible from grade on the back side of this property. And so the bottom section of that wall there that you see, that all stays. That stays in place until further determinations are made about the use. And the excavator has easy access, and it'll be very controlled and methodical process to come in and remove it section by section. And I could also, I do want to note, there was reference to a dumpster showing up this morning. I want to be very clear, there's been dumpsters on that site in and out for the last 3 months. It's entirely unrelated to the matter at hand. We are doing some work on the adjacent property as well. We are not predetermining the outcome of this meeting and prepping for an immediate demolition this evening.
Thank you.
We, along with McKinley Builders, who's also present here today, have done some very delicate demolition work, and it's really a matter of pinching with smaller equipment, no wrecking ball, no big crane, and it's really what you need to do in the historic district, and nobody wants to take on responsibility, that ripple effect of things that affect other properties. But it sounds like the owning entity is willing to consider a new condition that maybe the demolition of the retaining wall down around the perimeter of the property, the fence, can remain intact until you have another application for what would replace it. Honestly, we could use our money better to rebuild the same thing in the same footprint, but probably we don't want to build it right up to the neighbor's retaining wall. Probably we don't want to build it right up to the alley. So it really would, I think, want to take on a slightly different footprint, whatever replaces this. And the only adjustment I would make to what Jonah said is more than likely we would remove the slab, remove the foundations, and just leave the dirt in line with where the slab is now, because we've got to do soil studies, we've got to remove some bad soils, compact some new soils, all with very minimal vibration. And we can, once we know what we're gonna come back with, how we're gonna come back with it, we can meet with the owners and say, this is gonna be the method, but that information really is not known yet. And just one further clarification, Mr. Bryan said my project was the 226 in the report. That happens to be 226 South Front Street. I was referring to 226 North Front Street. Just a miscommunication there, which is the common desk property. So that's all. Oh, and on the issue of timing, you know, I had property swamped by Hurricane Florence too, out of service. It's a big impact. That's a long time. So waiting another year is really not, you know, it's punishing to the client, in my personal view. So I really hope to see the board not go in that direction.
Anything else? Anybody? Questions?
I have a question of the initial applicant. A question was raised about the condition of the building in any inspection, and your response was, I cannot address that. Are you saying you don't wish to, you don't have a report, there is no report? What's that around?
Mr. Dicker was not part of the project at the time of the purchase, and so was not around when the acquisition occurred, and that's the reason he's not able to speak to some of those issues. I understand there was an inspection done, and I don't believe a number of these issues were flagged or caught at that time. Many of the issues that were presented tonight are not visible or were not visible in the interior of the building at the time. A lot of them were discovered during destructive testing of the building that was discovered once mold was determined to be present and required further investigation. And you can certainly add on to that if I've misstated, but a lot of these issues were discovered during the process of destructive testing to figure out the source of the mold.
And the building, how long was the building empty? Do you know from the time you purchased it? I know it was closed in sort of a foreclosure, and then it sat empty for a long time, which is probably when a lot of this damage occurred. But
that is not correct. The property went through a substantial remodel immediately after purchase and was remodeled top to bottom on the interior. There was some new mechanical put in, not all of it was replaced, and the damage in substantial part was after the fact. It was not beforehand.
So this mold damage that you're showing us on this front page occurred after the work? This is
That
after
is
the work
correct.
was done?
Those images are reflective of the new finishes that were installed in 2018 and 2019. Those are not pre-existing.
And I'm not sure if this was caught earlier, but at substantial completion, the mold was being noticed at that time. So the property as renovated was actually never open to the public for use. And so my client has gotten no functional use out of the property since it was purchased.
Any other questions? Thank you very much.
Thank you.
Yes.
I just wanted to speak to the applicant's statement twice this evening that the retaining wall, which is on our common property line, is quote-unquote mine, and that it is quote-unquote failing. I don't know that a determination has been done of who owns the wall. Actually, if you look at surveys, it appears it's on the adjoining property line. So I think that's to be determined and not in the purview of this meeting this evening. I do happen to have, since Mr. Jonah is not a licensed engineer, I do happen to have a letter by a licensed engineer with a seal stating the condition of the wall at this time, and I'd like to enter into the record. Thank you. And I do appreciate your consideration for whatever protections can be put in place to secure our homes and the viability of our own structures as this work continues. Thank you so much.
Thank you.
Thank you for an opportunity to respond to some of those remarks. We're here, I heard Ms. Huffman and counsel for Warden Smith, the applicant, acknowledge the only reason we're here. And the only reason we are here is the very back page of the document I gave you. It's paragraph 15. It's the interpretation of the word exterior. And that's it. That's the only reason that this gets in front of you all, is that they acknowledge the sanctity of this, in my opinion, sanctity of this order with a judge. If you look at that order, the same law firm signed off on this consent order with the judge. They signed off on the settlement agreement. And so there's been no dispute about the consent order. There's been no dispute about the settlement agreement. They're just saying that paragraph 15 of this ordinance, and it's also written in the settlement agreement, gives them the right to come before you. And we have to say that exterior, this paragraph about lighting, and my clients happen to be at these settlement discussions and happen to be aware that this was all about lighting, and that to expand this definition of exterior changes to equal demolition, where's the word interior? Okay, they want to change the exterior, we can demolish the building, but there's no word about changes to the interior under this. If their position is exterior gets us here, I say interior prevents you from granting a total demolition of the building. You know, and I just want to bring you back, since everybody seems to agree that are parties to this agreement, to the consent order, which I argued earlier included this commission. Paragraph 3 of our order, where the judge clearly states findings of fact, conclusions of law, in terms of this consent order, are binding upon the parties and their successors and assigns, and may be amended or modified only by order of this court or agreement of the parties. And that's where we're back. And I was glad to hear that all parties seem to agree that this consent order is valid, that the settlement agreement is real, and that the broad use of the term exterior gets them in front of you for a demolition, which I think is a stretch at best. Any questions? Thank you.
What we agree on is to disagree. Counsel is well aware that my client does not agree with his position or interpretation of the order. He's well aware that the city's attorney's office does not either and has emails to that effect. What we agree on is that my client has a right to have a certificate of appropriation for you. We may disagree on when that should be heard, and we won't belabor those points here. But what I haven't heard with respect to the consent order is which term, which provision, which finding of fact, which conclusion of law has not or is in violation or in question here. There's nowhere in this document, either of them, that says that the exclusive use of this property is a two-story guest hotel. That's just not in there. At the time that the order and settlement agreement were entered, that was the contemplated use, and there are conditions associated with that use. While the structure is used for that purpose, those conditions apply. We don't disagree with that, but I just want to make sure that the record is clear that we do not agree, as counsel suggested, as to the application of the settlement agreement or the consent order. And whether we do or don't has no bearing on what the commission considers tonight. That is a question for the courts to decide. There is no legal action pending at this time filed by any party, the city, my client, or the Carrolls. Thank you.
Thank you. Anyone else? Okay, we'll deliberate now. I'll close the evidentiary portion of this meeting. Oh. Were you sworn in? No, but I will. Are you giving evidence?
I just have a question when the woman had mentioned that it was an African-American school at one time. And I think that is historical, whatever the word is, that should be should be considered. If in fact that's true. And I don't know.
Well, then, I don't think, what we require is that people are giving evidence, not just opinion. So if you have evidence to give us, then you can speak.
Well, I mean, I would think that would be new evidence.
Do you know that's the fact?
I don't. She does. She had the information. So it was just because if it was in fact a school for the African American community, Wilmington has an extreme history of overthrowing the African American. I just wanted to bring that up.
Thank you. Okay.
I apologize, I didn't bring it with me. I was stuck in the weeds at the North Carolina room at the library and reading both about my house and this property and surrounding properties. But that I'd be happy to supplement the record and can provide that information. But to the best of my knowledge and understanding, what is now called St. Thomas Preservation Hall, which is used, I think, as an event center, which is the gorgeous sort of taupe colors, sort of rosy-colored building right on Dock Street. That was originally St. Thomas Church, which I believe, and again, this is my understanding from just memory from what I've read, that it was an outreach to the African-American community, and then that evolved into a compound, some of which is part of the Arrive Hotel complex, to the best of my knowledge, meaning being a convent, and that is, I believe, where some of the nuns who taught at the school where they lived, and then what was St. Thomas Church also had a high school, I think, in the basement. And while all that was going on, then they decided to build, in the outreach to the African American community, decided to build what they called, what's in the papers as St. Thomas Parochial School. And my understanding, that was strictly for African American children to teach them, and that ultimately, after desegregation, that actual school and got rolled into the St. Mary's Catholic school, which is further down the street. That's the best of my understanding of that.
Thank you.
Thank you.
We're closing the evidentiary portion of this hearing, and now we'll deliberate. Does anybody have anything they want to say?
Well, I'm certainly glad we have two attorneys with us on the commission up here, so you can help us work our way through this.
Well, as Melissa said, our role here tonight is very narrow. It's whether we're going to allow for the demolition, keep the stay at 365, lower it to 0, or somewhere in the middle. And I can't give a legal opinion, and we're not really here to do that. So whether we want to not hold the 365 days for the fact that it is a very long period of time and come down maybe to 3 months or 6 months so that things can be worked out more easily, and if there's any legal action or court action that the neighbors want to pursue, they have time to do it in. And that's pretty much what we're here for.
Well, my question might be, I'm a little confused about what they want to work out. I know there's a big issue with the retaining wall. The client brought up the notion that they're not sure who even owns the retaining wall between the properties. And that seems to be to me, the only sticking point about kind of what we're talking about here with the demolition. So I don't know, again, what a stay of demolition might accomplish. Okay, I'm not saying I'm against a stay, but I'm just questioning what will that stay accomplish for both parties. And I've heard both of you say that you want a time to agree, you want time to discuss this, but I'm not sure within the purview of the law and the guidelines that we have that that discussion period is even relevant. Now, I'm not saying it's not good or we might not grant that stay of demolition, but just saying that I'm not sure that would accommodate or solve what you think are problems with the retaining wall issue. We cannot say anything about what may go on that property, future endeavors. The only thing we can talk about is the demolition and the stay of demolition if that is the purview of the commissioners. So, thank you.
I guess I'm somewhat in favor of doing a 2-month or 3-month limit so that if any action's taken, that we're allowing time for that to happen. And I think it's very critical. I think the board here very much wants to protect the surrounding houses. I think that's essential. So that if we need to have some time, whichever way they decide they can accomplish that, I think we should give some time there for that. I think 365 is a little too much, though.
I'd like to offer a comment. I do believe that there is merit for a stay of demolition, not 365 days, but I think the adjoining property owners, the neighbors who will be most impacted by this, have made their case of concern. And I do come back to the one sentence that from the standards for us is the impact of a proposed demolition on the overall character of the historic district and adjacent buildings. And clearly, the applicants that we've heard from tonight have addressed that. I do believe that there is some historical connection between the three buildings that was addressed. That was in my notes before that the convent, or where the nuns stayed, the school, the black church, St. Thomas, is very real. And although the building was built in the 50s, the early 50s, I don't think we can just disregard the merits of buildings built in the 50s. I think that there's been enough comment from adjoining property owners to warrant a stay and look at this for all parties to come together and not grant this stay tonight.
I agree. I think that there's been a lot that we have not been given, as far as, very vague, why it wasn't inspected or was it inspected. There's not been very much communication with the neighbors. Most of the time I've seen when developers come in, they will invite different, the neighbors over to come talk about what's going to happen in the community in New Hanover County or Wilmington. And it doesn't seem that there's been a lot of, it's very vague. And I think some things need to be hashed out and talked about before any stay is given.
I have one other comment I'd like to share also, and it was in my notes that I made throughout, but I appreciate the extensive engineering report and all the photographs, and clearly the building is damaged and has suffered insult. I also have lived in the district and watched enough homes and buildings redone that were in terrible shape and that were salvaged. So and people have taken on that task, so I just, I have to inject that in my comments.
Start a motion?
I would just like to add a fifth condition, that any demolition does everything conceivable to reduce the impact of vibration and damage to the surrounding properties. I'm not an engineer and I don't blow up buildings, but I'm sure there must be methods that are less destructive than others to the surrounding areas. And whatever those methods are, I would like those addressed and somebody to, look into that. I don't know if the city can or whatever, but yeah. I just have this vision of this giant monster machine, and if they put it in that back parking lot, okay, fine, but that's even closer to some of the other houses. And these machines just moving vibrate the ground. I've been there. I've managed properties that we have actually gotten counsel to go against another property because of damage to walls and parts of the buildings. So, yeah, I get it. This big machine goes and grabs the piece and all that. That sounds good, but can they maybe have a smaller machine or something, or whatever methodology can be done not to shake and rattle and roll the retention walls in these other homes, because these other homes are definitely historic. So I would like that fifth condition on there, please.
I agree. I don't know that we need a 365-day delay, but the neighbors have considered and valid concerns, especially since this is such a tight location. The neighbors are so close that I think there should be a little time for them all to understand what's going to happen and get ready for it, and not just have something start shaking in the middle of the night, which we've all seen happen.
I would be kind of, at this point, the applicant says that in this process, they've already had 30 days. Apparently with all the council here tonight, they have used some time of that 30 days. I think maybe another 60 would be appropriate to have them talk to each other and try to work things out, and also make sure that whatever methodology is done is as safe as absolutely possible. I appreciate that you all spent like $2 million to investigate all this stuff and to write these reports. That's a lot of money, but still, let's not kind of rush it at this point. That's my opinion.
I agree. I would say 60 or 90 days.
Did you say 60 days? Is that what you're?
I said 60. They already started with a 30-day with this meeting and whatever they did, so give them another 60. Hopefully that's enough time for anybody, I guess Ms. Hoffman would know this, but to file an injunction or do whatever they need to do legally if they're going to proceed more, or they can talk to each other.
Well, what would be the proposed outcome of the discussions between the clients? If we give them 60 days to discuss things, what is the proposed outcome of that discussion period? Is there?
I would think that they get information, or they have time to process an appeal or go to court. based on this other
For the appeal, because,
order.
again, reading the consent order, it deals with alcohol, exterior lighting, and a number, guest lodging, and about the number of units available on the property. So I don't see how any of those are being violated, you know, because the new building or whatever is going there would have to still adhere to these requirements about no alcohol and
Yes.
no exterior lighting. So I'm not saying I'm not in favor of the stay for the purpose of discussion, but I'm just asking, is the end of the 60 or 90 days, other than filing an additional lawsuit or injunction to prevent it, is it really going to accomplish anything? I mean, it may, but it's not going to change the consent order. It's not going to change the fact that the client wants to demolish the building. But if the council feels like I'll vote, you know, however, if we want to do that, then
Well,
I'm in favor of that too.
I think it could change. It could change the consent order, and it will at least give people satisfaction that there's been information exchanged.
Okay.
And I think that's what's been requested for the most part by the homeowners, and adding the fifth requirement of the type of demolition, I think, is critical, and that they know this and that that's all documented.
And I'd like some time to read this too. We've been kind of thrown a lot of information tonight.
And that's not in our purview either, so.
I know, that's not in our purview, but, you know, it's not in our purview, and so let's send it to other purviews, you know?
Well, I mean, since the applicant states there's no plan, this is not like, oh, we're going to put up a 20-story hotel next week. You know, there is not a rush, so I'm hopeful that people can talk and discuss and come up with some kind of meeting of the minds here, basically. I think 60 days is ample time. I think 365 is a wee bit much. But, you know, and then again, put in the fifth condition.
I agree.
It's the most divisive issue that I think I've seen come before us in quite some time. I mean, to the point that one attorney actually said it shouldn't be here before us, but it is. And I understand we don't have the right to deny it, so I would say we split it in the middle and do a 180-day stay. I just also want to comment that, yeah, I do think a fifth condition would be necessary. You know, provisions should be put in there to protect adjoining property owners' walls, and they do, I think, have the right to know the dates of when such work will commence. As far as historic significance of the building, yes, it has historic significance, but it's also a non-contributing building. Let's remember that.
Right.
So, you know, we can put up a plaque to the historical significance of the building. But I'd say give them a 180-day stay.
I can't,
demolition.
I mean, these are all very smart people. I can't believe it's going to take them 180 days to discuss this. I mean,
I was just splitting it down the middle, trying to be fair.
This still seems like a long time period, but I mean, I'll go whatever the.
90, can we try
About 90.
Do we hear 90?
These seems plenty appropriate. I mean, did you just pull 180 out of the air? I mean, why do you think 6 months?
I was splitting the 365.
Well,
you know.
well, you know.
I mean, we've got these two sides, you know.
Yeah.
Anybody want to do a motion?
I'll do a motion.
90.
I move to allow for a 90-day stay of demolition and approve eventual demolition of the existing building at 117 South 2nd Street. Details as shown on the drawings, plans, photographs, submittals, and narrative statements contained in the application and supplemental materials and statements made at this meeting are part of this request unless otherwise noted. This motion is based on the evidence presented before us, the application submittals, testimony, staff report, including the findings of fact. The following conditions shall be applied to ensure compliance with the design standards, those set forth in the staff report 1 through 4, as well as the following additional condition, number 5, to reduce the impact of vibration and impact to neighboring properties. And the proposed request with conditions complies with the Wilmington Design Standards for Historic Districts and Landmarks, applicable design standards 6.2 demolition standards 1 through 8.
I second.
All in favor?
Aye.
Motion passes unanimously. Thank you all. Item number 2.
I'm never going to see my cousin. I'm not going to see her cousin.
Carter.
Sorry about that. All right, so this house was built circa 1925, and it is a contributing resource to the historic district. The property is located at 207 South 2nd Street and is within the historic district residential. In this district, alterations to all facades of a building and site are subject to design review, regardless of whether they can be seen from the public right-of-way. The application before you today is for the construction of a rear addition and after-the-fact removal of a tree in the rear yard. The applicant proposes to construct a 249-square-foot rear one-story addition. The roof line would not extend above the existing roof of the house. The addition would align with the exterior wall on the north side and would have a slight indent on the south side to help denote a later modification. The addition would use materials to match those on the house, including wood siding with a 6-inch reveal. The applicant originally submitted vinyl-clad windows and fiberglass sliding doors, but confirmed later that they were not wood. I believe the applicant has come prepared tonight with revised product sheets for the Commission's consideration as replacements. Here is the north elevation. They intend to extend it out from the 2014 rear addition. A vertical trim board is proposed to represent visual evidence of where the new construction occurred. Here's the south elevation showing the addition proposed with a slight setback from the current exterior wall on the house. The exterior door and light would be reused. The applicant is also seeking approval after the fact for removal of a pecan tree in the rear yard. It was stated that there was a misunderstanding with the tree company. On January 11th of this year, a COA was issued to remove a laurel oak tree in the front yard. The city arborist inspected it and found it to be in poor health. The rear yard pecan tree was originally included in the submittal, but the city arborist found no reason to warrant its removal. Both the laurel oak and pecan tree were unfortunately removed at the same time. The design standards note that additions shall be compatible with the historic building in massing, scale, height, form, materials, proportion, and roof form. Locate additions to the rear or an inconspicuous side of the building. Materials shall be compatible with the historic building, and synthetic materials are not appropriate. With that, we'd like to enter the staff report into the record for tonight's proceedings.
Any questions for staff? Thank you, Ivy. Would the applicant like to present any information? Please state your name and address.
Good evening. My name is Mark Rhodes. I am the homeowner at 207 South 2nd Street. Good evening, Madam Chair and Commission members, and thank you for having me tonight. A special thank you to Ivy, who worked pretty closely with me on submitting the application and giving guidance. I appreciate that. I do have new product sheets for the doors, the sliding door and the windows at the back that are all wood. I think the initial ones that I found were wood, but they had some sort of a clad coating on it. So once we determined that to be the case, we found some wood, some doors and windows that are 100% wood. So I'll pass these product sheets over. So the existing house is about 1,000 square feet, and it is a second home for my family and I. It's a 2-bedroom house that we love. But as our 3 kids are getting a little bigger, we're finding that we're kind of outgrowing the space. So that's why we're seeking to do a bump out at the back. It's approximately 240 square feet. And yeah, I think hopefully it's a little more straightforward and possibly less controversial than the prior application. And then lastly, I guess in addressing the tree, so I did seek and get an approval for the removal of the oak tree in the front yard, which quite frankly was the reason we bought the house. We really loved that tree. But when the arborist came to inspect the pecan tree, he notified us that the tree in the front was in bad shape. So this was back in January that we got the COA. I think in February-March timeframe, I had taken estimates from 6 different tree companies to have that tree removed, and I shared with them that when pricing the job that I would likely be removing after I get the approval, if I get the approval, another tree in the backyard, and could they please price the job together. The company that I went with, Fitness Tree, I think they came out the day before they were going to remove just the front tree. And they, again, were aware that it was one tree first and then the second tree later. They actually came on site and determined that it was out of their comfort zone, and they canceled on me. So I went back to the other tree companies, decided on one, but since I guess time had lapsed, there was a miscommunication. And when they came out to remove the front tree, they removed both trees. We were out of town at the time, so we weren't there to know what was going on, and hence the violation. And I accept full responsibility for that. And that's all I have.
Thank you. Any questions for the applicant?
Just wanted to note that on your plan here on the, what page is this? I'm sorry, 34? Just a building science note. You have this new gable coming out of the back with no airspace. So the designer noted that you would just be putting presumably bad insulation, but that little gable, when you don't have the airspace, like an attic space, if you will, you're going to have to use foam insulation in those 2 roof areas. And that's something that you would want to do before you take this to inspections department and get approval, just to note that that would be foam insulation at that part of the back.
Got it. Okay. Thank you. Appreciate that.
Anything else? Thank you.
Okay. Thank you.
We'll now open the evidentiary proceeding. If anyone wishes to give evidence, will they please come to the podium? No one? We'll close the evidentiary portion. Any deliberations?
I just have a comment to staff. I happen to live in that block, and unlike the COAs that are posted, when a permit's been granted on a property for demolition of a tree or removal of a tree, it would be nice to have it posted. That block was closed for 2 solid days with construction gear. 2 days, it was completely blocked. And I was alarmed when they showed up, and the contractor would not talk to me. I asked if they had a permit. So I had to go through the city and reach out to staff. But the consideration that when large trees are scheduled for demolition, that neighbors are given some notice because the block was closed for 2 days to traffic and with no warning whatsoever. So I just mentioned that as a thought going forward in the district for when trees have been granted, so that nobody's surprised, nobody's alarmed whether this tree has been permitted to be removed. Thank you.
I just have a question of Ivy. In your findings of fact, number 11 states that staff had found no recent precedent for an after-the-fact removal, excuse me, approval or denial of tree removal. So what are we supposed to do with that? I mean, is there a fine for the after-the-fact removal, or how does that get handled?
Oh, sure. Essentially, he did already pay a fine. It was established that after-the-fact work would be required of the applicant, to pay an additional $100 fine upon resubmittal of an application for approval by the HPC. And of course, there's going to be nothing we can do to replace the loss of this tree, but in order to help remedy it, we have also included an additional condition for your consideration for the planting of a replacement tree.
Right, okay, thank you.
Anybody else? Somebody want to make a motion?
I would move to approve with conditions the request to construct the rear addition and approve the after-the-fact removal of the pecan tree at 207 South 2nd Street. Details shown on the drawings, plans, photographs, submittals, and narrative statement contained in the application and supplemental materials and statements made at this meeting are a part of this. This motion is based on the evidence presented before us, the application submittals, testimony, staff report, including the findings of fact. The following conditions shall be applied to ensure compliance with the design standards, those set forth in the staff report, numbers 1 through 6. I think the proposed request with the conditions does comply with the Wilmington Design Standards for Historic Districts and Landmarks. Applicable design standards, 1.6, Secretary of Interior Standards, 2 and 9, 3.2, Windows and Doors Standards, 5 and 6, 4.1, Addition Standards, 1, 2, and 4 through 6.
Second, anyone?
A second.
All in favor?
Aye.
Aye. Opposed? Passes unanimously. Thank you. Item number 3.
This is the Bowden House. It was built circa 1885 and is a contributing resource to the historic district. The property is located at 114 North 7th Street and is within the HD, the historic district. In this district, alterations to all facades of a building and site are subject to design review regardless of whether they can be seen from the public right-of-way. The application before you today is for the construction of a porch addition on the rear of the house and the addition of French doors to access that said porch. The porch would align with the exterior wall on the north side and would have limited visibility from the public right-of-way. Here is a photo of the rear yard showing the location where the porch addition would extend out from the existing bump out on the rear of the house. Here is another view of the area on the rear of the house in which the porch addition would extend out. Here is a plan of the proposed porch addition. The area outlined in red is the porch addition location, and the area circled in green is where the proposed French doors would be installed. This is the south elevation showing the proposed porch addition extending out from the rear of the house. For your consideration, the applicant is also proposing to use a composite decking called Fibron Sanctuary. The design standards state that materials shall be compatible with the historic building, so staff has included a proposed condition that the decking be wood and that the commission consider that as part of its review. Here we have the north elevation. You can see where the applicant proposes to install louvered wood panels with angled slats. The panels are proposed only on this elevation. Here is the rear elevation showing a different perspective of the proposed porch addition. The applicant is proposing to create a larger opening to install French doors in place of an existing vinyl window on the exterior wall to access the very same porch before you today. The design standards state that additions shall be compatible with the historic building in massing, size, height, form, materials, proportion, and roof form. Locate additions on the rear or an inconspicuous side of the building. Materials shall be compatible with the historic building, and synthetic materials are not appropriate. With that, I'd like to enter the staff report into the records for tonight's proceedings, and I'll go ahead and pass around a sample of the decking that is proposed by the applicant for the project.
Thank you, Ivy. Any questions for staff? Would the applicant like to step to the podium and speak?
Thank you, guys. She's really pretty thorough
Could
right
you
there.
give your name and address, please?
Sorry, I'm Steve Venters. I'll be the contractor here with these fine people. I'm a little more plain spoken than the attorneys that I followed for case number one. The porch in the back, we're going to use the same roof line, same shingles, same boxing, same columns, same trim as in the front elevation of the house. The only change they're asking, as per the homeowners, is for some synthetic decking in the back. In her behalf, I told her I would come and ask. Thought it was a long shot. It was 120 degrees in Canada this year, 109 in Seattle. And she's environmentally conscious. This material we've chosen, while it matches almost identical in color, is partially recycled and synthetic. A bonus would be for them, in our environment, there sure would be a lot less repairs. There's big trees in the back, and I got a covered porch. So no matter what I put down, even with treated, it's going to be pretty extensive as far as maintenance. And I'm saying that on her behalf. Everything else is wonderfully spoken.
Any questions for the applicant? Thank you.
Thank you, guys.
We'll open the evidentiary portion of the meeting tonight. If anyone wishes to present evidence, please come to the podium. No one? We'll close the evidentiary portion and have deliberations. Does anyone have anything to say? I think it looks great. Motion, anyone?
Wait a minute, what are we?
Well, if you have anything to say.
What about the deck again? I mean, standard is wood.
Standard is wood.
Right, so we're showing this piece of deck, but I mean, we're voting for wood, correct, not artificial?
You can, whichever way you want to go. And you can require wood, yeah, but you don't have to.
Well, it's in this, okay, all right.
I mean, would the applicant be agreeable to switch to wood?
Yeah, condition number 2 does state that the porch decking shall be wood.
Right, and that is the standard.
Yes.
I mean, Ivy has that as condition number 3. Excuse me, number 2. Sorry.
Anybody else? Going once, going twice. All right. I move to approve with conditions the request to construct a rear porch addition and add French doors to the exterior wall of 114 North 7th Street. Details as shown in the drawings, plans, photographs, submittals, and narrative statements contained in the application and supplemental materials and statements made at this meeting are part of the request unless otherwise noted. This motion is based on the evidence presented before us, the application submittals, testimony, staff report, including the finding of facts. The following conditions shall be applied to ensure compliance with the design standards, those set forth in staff report 1 through 4. the proposed request with conditions does comply with the Wilmington Design Standards for the Historic District and Landmarks, applicable design standards, 1.6 Secretary of the Interior Standards, Standards 2.9, 3.6 Porches and Entrance, Standard 3, 4.1 Addition Standards 1 through 6.
Anyone want a second?
Second.
All in favor?
Aye.
Aye.
Opposed? Motion carries. Thank you. We'll do item 4, then take a little quick break. Item number 4.
Where are we? Okay.
The subject building was built circa 1985, and it is a non-contributing resource to the Historic District due to its age. The property is located at 115 Ann Street and is within the Historic District residential. In this district, alterations to all facades of a building and site are subject to design review, regardless of whether they can be seen from the public right-of-way. The application before you today is for the construction of a front porch addition and removal of several bushes along the front of the house. The applicant proposes to construct an approximately 129 square foot front porch measuring 21 feet 6 inches wide by 6 feet deep by 10 feet 1 inch high. The existing bushes to the left of the front door and the concrete stoop is proposed for removal. The porch would be a one-story addition. It would have a shed roof with shingles to match that on the existing townhouse, simple square wood columns, a concrete slab, and a tongue-and-groove wood ceiling. One outlet and 2 ceiling fans are also proposed. Here is a side view of the front porch addition, displaying its simple design and form. The design standards state that porches and entrances shall be embellished with only those decorative elements that are in keeping with the character and era of the building. The design standards state that additions shall be compatible with the historic building in massing, scale, height, form, materials, proportion, and roof form. Materials shall be compatible with those of the historic building, and synthetic materials are not appropriate. With that, we'd like to enter the staff report into the record for tonight's proceedings.
Thank you, Ivy. Any questions of staff?
I'd just like to comment. I think that the circa date on that could be wrong. I came in '79, and I think all of those were built at that time. Yeah.
That was the information we pulled from the National Register nomination, so thank you for that.
Is there going to be a gutter across the front, too?
They're going to have a rain diverter
That's all. Okay.
close to the edge, not right on it, but close to it.
Have the other neighbors that live in this building, are they aware of this applicant or of the addition?
I'll let the applicant speak to that, but they have mentioned that they have spoken to the HOA about this project.
Would the applicant like to come forward? Please state your name and address.
Hi, Paul Biancardi, 115 Ann Street. White's over there. In answer to your question, I'm actually the president of the homeowner association of the building in question, and we actually had a meeting about it, and there's actually multiple people that want to do something like this to their home, and so we were nominated as the first people to do it. Also, I've talked to all my neighbors around, Joseph Pollock and George Sappho and all the other ones around there. They all think it would be a great addition to the area. We also had Ivy come by and look at the property. Well, she brought someone else with her, and they thought it might be a nice addition as well.
Questions for the applicant?
Yeah, I do. I've walked through that area quite a bit, and it concerns me. I'm an architect and also a homeowner in the district, and that is going to be, I don't know how to phrase it, out of place. the 6x6 posts you have, to me, seem a little large for the scale of what you're trying to do there. You have no detail shown on any of the columns, so I can't really determine what the finished product is going to look like. And that's such a beautiful street right there. The trees, the houses across the street, it just makes a very scenic, beautiful part of our historic district. And I have concerns about coming out there and adding a shed roof with 6x6 columns on the front of this, just as an architectural element, and how it's going to impact on the rest of the street. We have no purview on what your neighbors may or may not do in the future if they decide to add one of these, but I'm just concerned that it's going to really change the whole dynamic of that building that you're in and the building next door. So I just wanted to address that. I mean, there's no detailing on the columns. I mean, do you have any thoughts on that particular item? Or
Is your objection to the size of the columns? Because I think 4x4s would probably be more than sufficient for the weight that you're talking about. Is that the question?
Well, yeah, that's one, and there's no architectural detailing. The way you have it shown now, they can just put up a 6x6 treated wood post, and that's the finished product. And I'm not sure that would be compatible with what all is there. You know, there is some minimal detail around the door, maybe some minimal detail around the windows that could be an inspiration for how you might treat those columns. And, you know, if you're going to do that, I think you could do, in my opinion as an architect, something more sympathetic to the nature of the building and the streetscape.
Sure. I'm sorry.
I'm just sharing my thoughts here, and I'm sure there'll be some commissioners that have different opinions on that too.
So the reason why we went with this design is we actually walked around all the other neighborhoods around, and we took pictures, and we tried to get something that was as close to what was, when you were looking at a shed roof, what was around the area. We were just trying to match the area as much as possible.
Right. Okay.
That's one of the, actually some of the pictures that we submitted were from the other shed roofs that were in the area. And then in the architectural design that actually has the to-scale drawings, might offer a little more detail as well.
Okay.
Are the columns going to be painted, or are all the wood trim details on the,
So we're open to that. If you guys want them painted, we can paint them white. I mean, that would match the trim of the house itself. We're happy to do that. Really, we're just placing ourselves in your hands when it comes to that.
But I didn't notice anything. There's no note in the plans that I'm just missing. But right now you don't have any indication in here of whether it's going to be painted or not.
So we would like to have it painted white to match the trim of the house. Yeah. Right. But if you want it just plain, that's fine as well. Actually, no, we did actually submit. We actually submitted a white. Now that I'm thinking about it, we actually submitted. Yeah, white.
If I may, the application is proposing to paint the porch details white, and I believe it's just the ceiling that would have a natural finish on it.
Yeah, that's right, yeah. Sorry about that.
What about landscaping? I mean, are you going to take these bushes out and?
Yes,
so. What's the plan there? I mean, it's very vague. I mean, I agree that it's just lines and no landscaping or anything.
Sure. So in front of the porch, there will be about 18 to 20 inches left over to the sidewalk. We would install planter boxes there to give some greenery to that area.
So in reference to the photograph, your porch would come all the way out to maybe where those little plantings are, where the hexagonal.
Yes, so you see that line, that's, so you have the sidewalk, and then you have that line, and then you have then that goes to the stair. The porch would go out to that line in the concrete.
Okay, so then there would only be like 2 feet perhaps from the sidewalk.
It's about 18 inches.
18 inches, okay. And that's, in my opinion, again, is going to change the whole dynamic of the proportions of the building. And it's not just your unit. You're in a building with four, I think there are 4 units there, is that correct?
There's
Or
3
5?
units in this building, yeah.
And then you have an adjacent building, I don't know if that's part of the HOA also?
It's the whole, the whole
Right,
structure, the
okay,
entire
so,
street.
so then you're coming in there, and if you add a porch here, you're going to change that physical dynamic. And then if another owner down the road wants to do the same thing, in my opinion, it's really going to impact on the streetscape. You're much closer to the sidewalk. You have almost a barrier there from the sidewalk, a visual barrier because it's like your front porch. And now you have some really nice little landscaping there that kind of is a separation. So I'd really have concerns about this being pushed out and only 18 inches from the sidewalk, and then some minimal little plantings there. So,
In answer to that, one of the reasons why we're doing this is because we're in that block. We're all very neighborly. We like to interact with the people that are coming by, and that's one of the reasons why this was brought up in our HOA meeting and something that people wanted to do. When we asked for, we were talking with Ivy about, could we have one whole consideration, and people weren't prepared to submit all of the appropriate documents to do this all at once, and really to get everyone to do that all at once would have been a lot of. So it's not something that every single owner is going to want to do, but there are several owners that are looking to do that. When it comes to the porch area, it really, in our mind, it makes for more of more community on the street and on the block, and that's something that we were.
I think that what you're proposing, I think if it were built when the building was constructed in 70 or 76 or 85 or whenever it was, I think if whether you had this by itself or everyone in the building had something like this, I think we would walk by now and not give it a second thought.
Yeah.
I think it would fit fine. I think the outdoor kind of living that we're all trying to improve in our lives, for lack of a better term, is important. I guess if anything, maybe to tie it in a little bit, on the overhang shows that the overhang, the soffit, if you will, or the overhang is coming at the same angle as the roof itself, a 4/12. If you just put, I think, a little soffit, because you have a horizontal, like at least a 2-foot soffit on the building itself, but at least if that thing were leveled off, I think with the 6x6s and painted, I don't have any qualms with it. I would caution that when you have your roofer do this work, that he uses flashing and tucks it into your neighbor's brick properly as well as yours with a piece of apron flashing across the top. You've got to worry about the waterproofing on something like this, but really nothing here bothers me at all personally, but I would just actually recommend having a horizontal soffit there for that little overhang beyond the girder. That the posts hold up.
That's good advice, yeah.
Well, question the gutter from the upper roof. Where is that going to go when this?
The gutter already comes down on the side, so that's so there's only one gutter. It comes on the side of the building. You see it on the extreme right there.
Yeah, but I mean, so the porch roof is not going to that extent over there? That gutter's going to remain just as it is, and it's because it's on the front. It's on the side, but it's on the front.
Yeah. Let me, Catherine, do you have I honestly don't know the answer to that. My contractor did the designs on that one.
Okay.
I'd be open to your opinion of where you'd like that gutter. Our neighbors are pretty good about that. When you're thinking about that, if it's going all the way over, then we're going to have to put it coming down the roof and then down to the 6x6 there. We could, to simplify that whole thing, we could really just stop it right before the gutter and then not have that problem.
Stop it right where the gutter starts, yeah.
Yeah.
And also, I happen to manage HOAs. That's what I do.
Yeah.
So I'm familiar with ARC and archetype. So my concern is what you build, and I agree with Chris here that what you build might kind of become the archetype for future porches in your HOA. So I think it's kind of important we get it right.
Yeah.
Okay. And we're only talking about something that extends 6 feet from the building. That's here to here. You can barely sit on that and extend your feet out without going. Scale-wise and massing, I think fits. It's not. This isn't an imposing structure.
But I have to agree with Ron. The 6x6 has just jumped out at me because it is such a small space. If 4x4, would work, I think that's a little bit better scale.
Yeah, we did 6x, yeah.
Three of those.
I'm totally fine with that. It's actually cheaper to do it that way as well.
Well, now, based on the photograph, the green building or the part of the structure that's green, okay, that would be the residence on your side. So is your porch going to be right up against their outdoor area? I mean, you could step off your porch and then be in their front door almost. Is that?
So if this is approved, they're one of the ones that are probably going to apply as well. Because they actually just recently did a whole bunch of renovations as well. So they're very interested in doing a porch as well. When it comes to that, if we're going to be stopping the porch before the gutter, then we'll have that probably about 6 inches of space there.
Okay, because the drawings don't indicate that, that 6 inches or whatever that you're saying.
Yes, sir. Yep.
Are any of your neighbors here tonight to speak?
They are not, no. They were all given the letters. We actually had a meeting about what we were going to do beforehand, and they all have no problem with this whatsoever.
In the packet that I'm looking at, I don't see any pictures of any of the surrounding porches that you took pictures of. Did any of them have turn posts, or are they all just 4x4s?
They were all 4x4, 6x6
all
posts.
4x4s.
Yeah.
I'm sorry, what was that? 4x4s, where do 4x4s exist on the buildings? I didn't understand.
No, on the other porches, he took pictures of, I was wondering if they had turn posts or they just simple 4x4s.
Most of them are just like simple shed roofs, just like this.
Simple, no, okay.
Yeah, we tried to match what everyone else was doing because we figured.
Okay, fair.
I'm not sure code would allow a 4x4. I guess if code did allow it,
that's the exact thing. So I would go with whatever the code allows.
I think with our uplift,
yeah,
and structural wind load requirements,
yeah,
I don't think 4x4 would suffice.
I think that's exactly why the contractor drew it as it was.
I think you can use 4x4s, Christopher, but I wouldn't.
Yeah, I mean, I'm not an architect or a contractor, so I cannot answer that question. I'm sorry. But we can absolutely talk to our contractor, and if we can do 4x4s, I'd be happy to do that.
Just a little bit like Ron in his description, I've tried to visualize it, and I'm not sure that it's going to complement the house. I understand your need for that transition and that break and a usable structure. It seems so plain, for a lack of a better word, and I'm not here to design it, but I think it's going to, if that porch is duplicated in multiple facades along the block, I think it's not going to be good compatibility in my way of thinking. I just had to share my thoughts. I could get used to some change. It just seems weak and non-contributory in terms of enhancement, but that's just my thought.
It is not to diminish the building, but it's rather plain. It's a very simple.
It is. That's one of the reasons why we wanted to do a porch, was because the building itself is very plain, and so to put something very elaborate on that I don't think it would fit. The other side of that is that we've looked at all the. I mean, when you look across the street, we have a bunch of historic houses across the street, and they all have more plain porches. They're not elaborately decorated. They don't have, like, if you go over to, where the historic preservation houses, they don't have any like exquisite metal work or anything like that. It's more plain porches. So we're just trying to fit the area.
Anything else for the applicant? Thank you.
Thank you.
All right. Thank you very much.
I will open the evidentiary. Does she want to talk? Okay.
I'm Catherine Biancardi, and I'm Paul's wife. We found a new build on 4th Street, and that's why we kind of went with this direction, is because we thought that got built recently. That would be something that the board approved, and the address on that was 405 4th Street. I can show the picture if anybody wants
North
to
or south?
see it. What would that be? They were right. South. So they did a very basic, just shed-style roof with a big post, and we thought, well, if that's what new construction is getting approved in the historic district, we'll just try to mirror something similar. But we're certainly open to any suggestions.
Thank you. Is there anyone who wants to give any evidence tonight? Please step, you sworn in now, right? Okay, please give your name and address.
Actually swear in.
Oh.
Eileen Mimi Ashton. I mean, it's nice that they're doing this, but I know it's an HOA, and I think he said it was approved by HOA, because HOA has to approve things before they actually get done, because he would do this. Then if I owned one of those and I said, oh, I want wrought iron, is it then going to be inconsistent all the way down? And if you remember, well, I don't think any of you were on the board, on the river walk where those condos are, someone was going to put one type of gate, and they didn't approve because, you know, it was an HOA situation, and he would do one type of fence, the next guy would do something else, the next person would do something else. So I just wanted to put that in your minds, that when you approve his, which that's fine with me, whatever you do, but the HOA needs to approve that. And then down the road, if the other people are coming, are you going to allow other than what he's got, or is it going to have to all be consistent? That's it.
Thank you. If you'd like to speak to that.
It was approved.
Any documentation that you could submit to show that it's approved, or?
I was not aware that I needed to bring that, but I could bring.
I don't know that you do, but I'm just asking. So.
No, the whole purpose why I'm here first is that to kind of get the process of this so that other people can do the same thing.
Well, if it's unapproved, that'll be up to the HOA to demand you remove it, fine you, take you to court. That's their thing, not ours. So, yeah.
Right.
I was made the president under duress anyways, right? So.
Thank you.
Thank you.
Evidentiary hearing is closed. Deliberations? Have any problem with it personally?
Again, I don't have any problems with it.
I think if they more of them did it, you'd get used to it and it'd look fine.
I do kind of,
would add value to.
I would like a condition that if building code allowed 4x4s instead of 4x6s, if building code allows. Because I just think 6x6 on this little structure seems kind of big to me. I mean, that's a chunk of wood there. That painted white. And I would like to have a little soffit in front, but if I guess there's restrictions obviously on the width of this thing, so maybe that can't be done, because that would look a little more like a formal porch. I don't want it to look kind of like a lean-to on the back of a shed, if you know what I mean. You know, it's simple, but in the front of a building like this, I don't want to be so simple. That makes sense.
I don't think they want the water. There is a diverter there, but in heavy rain events, it may overcome that. But I don't know if you want to have that edge of that fascia or the overhang to be right at the sidewalk height or level.
Yeah.
But maybe if you could just have a condition if a 4x4 was passed by building code.
Yeah. All right. I can
do that. If not, then I guess we'd have to be able to approve a 6x6 by default if code required that. I just can't recall right now if it does or not. I don't think it does. I think a 4x4 is too small.
I said you memorized the entire book. Okay.
Anyway, anyway, they can figure that part out. Ivy, do you have a photograph of the entire building that we could look at that shows all 3 or 4 units?
The best thing is on that page 3 that shows all 3 buildings from some time in.
Because, when we start to think about that, we're looking at one building, and it may be 3 condos that they've put together, but in reality, when you walk by, it's one building. They've changed the brick pattern or the brick color, but I think in observing it, you know, we have to look at that entire structure as opposed to just this one little unit that's going to be there. So in this case, we have a nice structure with 3 different kind of areas, and then we're going to pop out this shed roof, and the one next door, I think that unit sets back a little bit, the green one. So, and the unit to the right has a arch over the door, or you know, some sort of architectural character over the door, and I don't know, it just seems it's going to have a real impact on the look of that entire building, in my opinion. So, yeah, thank you for that, Ivy.
It will, but I think they're, unfortunately, I didn't have time to go down this block of Ann Street, but I know everywhere around, there are porches all over the place, obviously.
Oh, yeah, I'm not saying that there aren't porches everywhere. I'm just saying that they're coming in with a structure that they're wanting to add a front porch on, and then that's going to set a precedent for the other 2 units, and then for the other building in the HOA. So, I don't know, just in my opinion, I would, and there's nothing really the applicant to, but it seems like that building has to be considered as an entire structure as opposed to an individual unit, but in the appearance of it. But but thank you.
Motion, anybody?
I'll do a motion. I'll move to approve with conditions the request to construct the front porch addition and remove the bushes at 115 Ann Street. Details as shown on the drawings, plans, photographs, submittals, and narrative statement contained in the application, and supplemental materials and statements made at this meeting are part of this request. Excuse me. This motion is based on the evidence presented before us, the application submittals, testimony, the staff report, including the findings of fact. The following conditions shall be applied to ensure compliance with the design standards, those that were set forth in the staff report, numbers 1 through 2, with addition 3 being that the post, if allowed by code, be 4 by 4, and then number 4, that they be painted white. I believed with the proposed request.
And I'm sorry, the level soffit as well would be a condition I would. Well, I'm sorry, you're making the motion.
I'll add the level, soffit. I can agree with that.
Oh, and if I may, the application does already include a proposal that it be painted white.
That what?
That'd be painted
Oh,
white.
okay, excuse me. Okay, well then the 2 conditions will be the post can be 4 by 4 if allowed by code, and that the roof line. Soffit be, what did you say?
Level.
Be what?
Level.
More level. Okay, they're level, excuse me. With these conditions, I
horizontal. Sorry.
Do you want to redo it?
No, horizontal.
Horizontal.
What?
That the soffit be horizontal.
Horizontal.
Soffit be horizontal. Okay, let's get this straight. The request with these conditions, I believe, does comply with the Wilmington Design Standards for Historic Districts and Landmarks. Applicable design standards, 3.6, porches and entrances, standard 3, 4.1, addition, standards 2 and 6.
A second?
Second.
All in favor? Aye. Opposed?
No.
It carries. Thank you. We're going to take a 5-minute break now.
Sir, if your HOA starts making a lot of improvements like this, do you have master insurance on your property?
Yes, well, so everyone has their own insurance.
negative feedback. People have been coming in this week and maybe towards the end of last week.
It's not. Oh, horrible. Just like the upstairs in my house. Yeah, I can tell you. Which I want a whole new system. But I gotta sell a house to afford it.
My water's dripping.
Your water.
Back to the job.
Slam it down, girl. You did it. Keep them going.
Are we almost ready? Yes. Okay, we'll start again. Item number 5.
So here we have the Gilchrist House. It was built circa 1894 and is a contributing resource to the historic district. The property is located at 708 Market Street and is within the HD Historic District. In this district, alterations to all facades of a building and site are subject to design review regardless of whether they can be seen from the public right-of-way. The application before you today is for the construction of a rear addition and detached garage, exterior alterations to the rear and east building elevations, site improvements, and landscaping. The applicant proposes site improvements including brick walkways highlighted in yellow on the site plan before you. Gravel walkways and driveway are highlighted in light blue. 5 green lawns are highlighted in green. And permeable pavers for the parking area are highlighted in purple. The applicant is proposing to remove 2 existing trees in the rear yard, a 14-inch gum and a 16-inch magnolia. The oak tree on the far rear of the property is proposed to remain. Here's a site plan of the proposed fences and walls. Highlighted in pink is the wrought iron fence at 4 feet tall on the west side and 6 feet tall towards the rear of the property. Highlighted in orange are the 6-foot-tall wood lattice screen walls proposed. There would be 5 in total proposed as screening for each of the private lawn spaces for the residents. The applicant proposes some exterior alterations to the rear of the house. Here's a view of the existing rear corner of the house along the western edge. It is here that a rear addition is proposed to extend 10 feet out from the existing rear wall. The first floor would have paired windows on the side and 3 windows on the south. The second floor would have an open porch, and the third floor would have a Palladian window in the gable end of the roof. Here's a view of the existing central portion of the rear of the house. This addition was constructed sometime between 1978 and 1998. The applicant proposes to modify the window openings on this section. On the first floor, they would replace the vertical glass panels with fixed multi-pane windows and the door with a new pine full-light door. On the second floor, they would replace 3 multi-size windows with new ones to match the size and configuration of the windows on the remainder of the house. Here is a view of the eastern portion of the rear of the house. The applicant proposes to replace the horizontal windows on the first floor and the windows on the second with new windows to match the size and configuration of the windows on the house. The existing roof is proposed to be modified to form a gable roof with a new Palladian window. Here's a drawing of the existing east elevation. The proposed modifications to the windows are on the rear half of the house only. The applicant proposes to remove the first floor windows and add 3 towards the back to match the general size and configuration of windows on the house. On the second floor, one window would be removed and the other existing windows would be shifted south. I'd like to note the applicant has proposed Marvin Elevate fiberglass windows for the house. The design standards state that additions and exterior alterations shall be compatible with the historic building with respect to its materials. Synthetic materials are not appropriate. As such, staff has a condition proposed for the Commission's consideration that all windows on the house at least be wood. And lastly, the applicant proposes to construct a detached garage in the rear of the property. The garage would be a 2-story building measuring 48 feet 8 inches wide by 24 feet deep by 22 feet 9.5 inches tall. A central passageway is proposed to allow direct access from the garage bays and parking areas to the house. The garage would include a standing seam metal roof, fiber cement siding and batten strips, fiberglass multi-pane windows, and a flush steel garage door. The garage design relates to the house through the incorporation of the gable roof, lap siding, standing seam metal roof, and similar window configurations. It is differentiated by the garage door panel design, multi-pane windows, batten siding on the upper body of the exterior, and central passageway. The design standards state that additions shall be compatible with the historic buildings and located at the rear or an inconspicuous side of the building. Materials shall be compatible with the historic building, and synthetic materials are not appropriate. The standards state fences and garden walls have traditionally been used to delineate property lines and mark boundaries between public and private property. Fences of wood, brick, masonry, wrought, and cast iron are found within the district. The standards state that the style of a new accessory building may reflect the character of the main building or have a historically compatible utilitarian appearance. And with that, we would like to enter the staff report into the record for tonight's proceedings.
Thank you, Ivy. Any questions of staff? Will the applicant like to come forward? Please state your name and address.
David Lyle, 614 Market Street. I think Ivy did a good job representing what we're trying to do. This house has been under repair for the last couple of years since the hurricane has hit it. Over like a year and a half ago, I think they started repairing it. In the process, they have demoed the inside completely back to the studs and damaged a good bit of the house itself. Our goal here is to bring it back to what would have been the sort of original nature of the house internally. The additions are intended to be complementary to the overall architecture of the house. And the gardens, again, the yard is obviously for years have been in bad shape. Our goal here is to create gardens and spaces that make this unique lot and property very special. And be glad to answer any questions that you have.
Is the intention to do a VRBO or something back here in the garage?
The garage above is storage for the inside. So each garage is individually owned, and then they have a unit above which is for storage, and they have internal access for that.
Individually owned by whom?
This is going to be 4 individual units.
So it's not going to be this homeowner that owns the garages? It's going to be like a garage condo?
So basically the house will be condoed out into 4 units, And the units will each have their own garage and storage above.
Okay.
And they will have their own private garden as well, with one central garden that's community space.
Hey, David, I have a question. I think your addition garage looks very nice and everything. I do have a question shown up there, kind of where your entranceway is, and you've done the multi-paned slim vertical windows there, and then you're stepping them up on the side. Can you explain that a little bit?
That was an original stair that was there, and so we're maintaining that stair. It was enclosed 70s, 80s, whenever, but we don't want to tear that stair out, so the stair stepping of the windows, that's the reason for that.
Okay.
And the entrance will be on 7th Street to the garage?
It will be on 7th Street, correct.
Is there going to be any problem with the hardy plank?
On the garage?
I mean, I know we've seen where it's been a problem with other houses.
Detached new construction, so
New construction you can?
Can?
Yeah.
Okay.
My house is.
Houses, okay.
If you could please speak into your microphone.
Off during the break, I apologize. I did want to compliment you on the design and the packet. I found the highlighted red areas, you know, very helpful. It was very well prepared. I noticed under the conditions for number 4, the windows you're proposing are fiberglass. Are you agreeable and discuss with your client that those could be wood?
Sure, I understand that. Keep in mind that all modern windows, or at least not all, but the ones that we're presenting do have a wood interior. The outside is fiberglass. They're all basically composite type windows, and the fiberglass can be painted and it does match the style of the mullion. So we can do whatever you need to do. It's just that the wood now is just not good. So.
Anything else? Thank you.
Thank you.
We'll open the evidentiary part of the meeting. If anyone wishes to give evidence, please come to the podium, state your name and address, and present your evidence.
Good evening. My name is Chris Holcomb. I live at 17 South 7th. So I have experienced this house firsthand from the back. So where the garage is being proposed, I'm concerned about the hardy plank. That's one of my concerns. It's cementous board. I see it all over town where it's cupping and bucking. Also, as you had asked about the attic or storage space above the garage, I'm concerned that in the future that may become living space or be proposed to change into living space. Currently, 7th Street, where this property's driveway drops onto, is already a fairly busy street with now parking on both sides, which was instituted, I believe, about 2 years ago, which is fine. We haven't had problems. But I do believe that if you have more people living in this one condo / home, you may find crowding on the street and parking, and that, of course, affects livability in that neighborhood. I'm also concerned about the live oak tree in the back. I don't know if there's been an arborist who has looked at it, but I've seen the state of it, and its branches and leaves and stuff they don't look very good. It looks like there's a lot of rot. So after Florence, there were a number of branches that fell. I think at this situation, it would be great to keep it, but it seems that it should be at least looked at and possibly trimmed, if nothing else.
This is the tree, I'm sorry, the tree in the photos that are covered in ivy for most of it? Is that what
Well,
I saw?
no, there are a number of other trees. There's a tree actually that sits right on my property, right off of my property line, that is covered completely in ivy and looks as though it's ready to die. And after Florence, we had a tree fall on our house, and we had to redo our roof. The gentleman that removed that tree said that the tree that is standing with all the ivy is probably dying. So I'm not an arborist, so I don't know. I would certainly hate to replace my roof again or replace the back of my house with another tree falling on it. So those are concerns of mine with this. Also noted in the prints, the fence lines currently are not clear about what he's doing on 7th Street for an entrance. In other words, I see a lot of gates and fancy work at the house, but I don't see anything currently, either a gate or an enclosure. There's wrought iron and other things, but where does that wrought iron end? And then right now, we of course have chain link fence that's overgrown because the area hasn't been maintained. So I'm just curious how far, yes, great. So if we look at this and we go to the bottom right side, I don't notice anything noted for an entrance, gate, or otherwise, unless I'm seeing it wrong. So really my main concern right now is habitability for the neighborhood and not overcrowding. So I realize it's quadruplex. It certainly would be better than what was there prior. But I, again, would hate to see the garage become a living space in the future and then create more crowding and parking issues. I believe that's the majority of my concerns. Thank you for your time.
Thank you. Anyone else?
Hi, I'm Jenna Alt-Holcomb. I live at 17 South 7th Street, which is next door to the Gilchrist property in the back. And my house is also a Gilchrist house. It was built by the Gilchrist in 1907, and it was a rental, and it is called the Gilchrist Bellamy house. So they've shared property. The property was divided in the 1940s. My concerns are a couple of things. It was the women's shelter before. It was abandoned right before Florence. Nothing has been kept up since then. Even when the gentleman has bought it, he hasn't done anything except for show us plans, on what he wants to do. The live oak tree, which I think you can see clearly on page 12, has not been looked at by an arborist. The women's shelter, there was another live oak tree in front of our house, or on the Gilchrist property, that was removed. I was told at that time that the other live oak tree was rotten and needed to come down as well. That spreads basically over 3 or 4 properties, and it drops branches all the time. Parking is another big concern. It's a lovely plan. I think it looks beautiful. But if we're putting condos in here, I wasn't sure if it was going to be a quadruplex or condos or a single family house. But depending on the number of bedrooms, there is a total of 6 parking places proposed for that whole complex. And I don't know exactly if parking is changing. I know at one time it all needed to be enclosed. If the back gatehouse goes into living space, where are they going to park? The gentleman has also bought the property across the street at 8 7th Street, which is a duplex now, and that has no parking. So where are they going to park? I mean, we don't have a lot of parking on our streets, and I'm almost concerned that this might need a parking study to be approved, unless the city's just going to waive everything that has been standing forever. The other concern that I have is the material of the hardy plank on the back, it not being exactly what the Gilchrist house is made of, and that makes me a little concerned because I would like them to match if they're going to be there. And synthetic material isn't appropriate according to all the rules I've heard. I think I had, and then also the drive. The entrance into our house, or our driveway, is next door to their driveway, and then there's 2 plots of land. And their fencing isn't very clear how that's going to be around the property on the outside. And so if you're looking up the gravel drive and where the oak tree is there a privacy fence going along there or going along the other properties at all? Then you have, I spoke to the owner and he told me that he was going to buff out the gate entrance to that, which would impede my driveway. And there's no plans, you don't see any of this. He says, oh, it's going to have an electronic gate, it's going to do this, but it's not in this proposal at all. So that's really concerning to me as well. Let's see, and just, I think that is it. Thank you for your time.
Thank you. Anyone else? We'll now close the evidentiary portion, deliberations.
If I may, Madam Chair, I would just like to take a moment to note that the applicant and I did also sit down with zoning and have a preliminary review, so they do meet all base zoning requirements and parking requirements based on the floor plan that you see before you today.
Thank you.
Ivy, can you, I'm looking at the site plan provided in the package and then our 3D illustration up here. I'm a little confused on the driveway here that we're showing, and it appears that there's no exit from the top. I mean, and so at the bottom of this drawing here, that comes out on 7th Street, correct? Okay.
That's correct.
Okay. Thank you.
Sure.
I have a question about the screens that are proposed. Can you explain them a little bit more? Like how high are they? I must have missed it.
Maybe if the applicant could address a handful of things that were brought up would be helpful.
Pardon me?
Maybe if you could address some of the other issues that have been brought up by the other folks that are here tonight.
Well,
Sure. But for the screening, the intention is that each one of these gardens is associated with one of the condos. So each person has their own private garden. So the screens are 6 feet tall. They're wood lattice, and the intention is to grow ivy or something on them that kind of gives them some sense of protection from other gardens. And yet, they will all be open to each other laterally, but not off the porches. That was really the intention, just a sense of privacy. As for the storage turning into residential units, the applicant can come back at some point, ask for 1 unit if they wanted to, but it would have to be approved. At this point, because of trying to do 4 condos, there is no storage space in this house. They do get a garage, but again, it's only about 13 feet wide, 12 feet wide for each unit, so they need space. Most people have a garage and they just put stuff in the garage, and our goal actually is to give them storage space so they're using the garage for cars. Then they have 1 more space, and then we actually do have space down below on the right-hand side. If they had some guest parking or something like that, could be added in the future. There is no intention that I know of to put a gated entrance on this that's controlled in any way. We do have fencing that comes around the perimeter. That's to keep the gardens private. It is to match the existing fencing. It's going to be taller than what's on the Market Street side. It's going to be 4 feet tall, not 6 feet tall, or not 3 feet tall, it'll be 4 feet tall when it runs the perimeter. So I guess somebody could hop over, but it is just to match the existing.
So each condo gets 2 parking garage and then a parking space?
Correct. Was there other questions that you wanted me to answer?
The trees, any thoughts on the trees, or have you gauged the health of them by an arborist or anyone like that?
We have not engaged anybody yet, but again, I'm sure that we can ask somebody to come down and take a look at it.
I don't think that's a live oak tree from the nature of it. I'm looking at the branch structure. That's a strange-looking live oak. And also, that ivy will kill that tree. If you were to cut that ivy at the ground, I bet you it will stay alive on the tree for at least a month to 2 months because it's sucking the life out of the tree itself. I mean, so it really needs to go. If you want to save that tree in your plan, that ivy needs to go.
Okay.
But,
And the attached addition, that is wood siding to match the existing?
Anything that touches the house is going to match the existing house.
Is wood, yes. got
Except
it.
for, I guess the windows, if that's make you part of condition.
Yeah.
all right.
So there is no off-street parking required in the HD? Is that correct?
Maybe it does work. If you slam it on the table, it'll turn itself on. Because this is a conversion to a quad unit, there is parking required. It's 1.5 spaces per bedroom, so 6. Parking spaces will be required, and this site plan is compliant with that.
What did she say?
We can't hear you.
Yeah, okay, so the goal here of the garage is the garage door pulls into a garage space, then each unit has a stair that goes up to the upper portion, and they're blocked off from each other. So the second floor of the garage is for storage, and it's associated with the garage below it. Yeah, that's the intention, is that they will park in that garage. I mean, they purchased the garage and that storage unit with their space.
And the code would not allow accessory dwelling units accessory to the quad. So there would not be an option in the future to convert the garage space into accessory dwelling units.
Anything else?
I was wondering, I don't know if you're the one who might address the neighbors' concerns, that she raised, who might address those.
About the number of units?
Well, no, during her presentation, there were multiple from the driveway encroachment, it sounded like.
I thought I did. We are not intending, as far as I know, to put any sort of gate or fence in that back area other than what we're shown in purple up here, or lavender. If the owner wants to do that, he will have to come back and ask for that in front of you all. But that's not part of our purview of our design that we were supposed to do.
So 4-foot fence to the side, 6 foot at the rear, and then, but the driveway kind of gets enhanced in some way. I don't know if that's noted, what that driveway looks like and the access onto 7th Street.
Correct. So we
taking
have
care of that
we have a
concrete
concrete lip and then metal edging that holds the gravel in place. And then we have pervious pavers to the left and right of the tree, or top and bottom of the tree in this case. And so, yes, I mean, I think it's called out plainly.
Please come up to the podium.
So currently, on the right side of this drawing, this rendering, there is a chain link fence. There is also a chain link gate at approximately the line where you have 12 foot, 0, and 21 foot. So 5 foot, 12, and 21. So you have a chain link fence. that has a gate, is that being removed? And the tree I was referring to with the ivy on it is not the live oak, which is also being choked out by ivy, but there's a smaller tree.
Bear with me for a moment. I have some views in the report that show the driveway area and the tree as well.
Thank you. So the oak tree in the back that has the dotted line around it is the one that everybody's saying isn't an oak tree. It may not be, but the tree that I'm more concerned about is the tree in front of that. If you look above the oak tree to remain, there's a tree, and it is covered in ivy. That tree, literally, if I pushed it over, would fall into the back of my house. So I'm more concerned with that tree. I'm concerned with the oak tree too, because the condition of it doesn't look very healthy. That being said, the one that's going to make me pay for another roof is going to be the smaller one. But then there's a chain link fence, and you can see on the upper photograph, it's overgrown currently with weeds and ivy. Sorry, ivy. That is a chain link fence, and then that buffer yard where that wall is, so you have approximately 20 feet maybe between the buffer wall and that chain link. So is that chain link going away? And what will be done with that area currently is kind of my question. Thank you.
I'll have the owner look at the trees and see what we can do, what's on the property. It didn't show up on the survey as being on our property, so I'll have them look at both those trees with the ivy. As for the fence, the intention is to pull up all the fencing that's around that property. It's currently wood. It's a mix of all kinds of fences. The intention is to pull those fences up and put back what we're showing. No other fences are intended at this point that I know of.
If I may, we would need to add that aspect to the application. I don't believe removal of the rear fence was included as a work item. Just on the side on the west part of the site.
Okay.
I actually live across the street at 16 South 7th Street, and I came here basically to support. But I have a question, because I never heard, they're going to be condos and not apartments. I keep hearing the word condo, and I didn't know if that makes any difference, but I'd like to know. That was it.
They're condos.
Any further deliberations by commissioners? Does anyone want to make a motion?
I'd like to hear a sense of other commissioners about the trees. Is there any provision we would have for trees on this?
I mean, I would like an arborist to look at the tree, and I'd certainly have that ivy removed from the tree, because it will kill those trees. And boom. I'm saying that I'd like the ivy to be removed from the tree, and an arborist to look at those trees that are supposed to stay. Because obviously, the one with the heavy ivy, and I could just see limbs coming off that tree, might even hit the new garage. So, I mean, that needs to be looked at.
Or a person. I mean, they're dangerous. They hit a person, too.
Oh, yeah. Yeah. And if the arborist determines that those trees, those additional trees, those two that are both covered in ivy, if the arborist were to say that they're done to...
Too far gone?
Have them removed as a part of as a condition potentially.
I'd agree with that. I mean, if they can't be saved, because then they would be dangerous. plant a new one. But,
And Ivy, you said the link fence, that whole issue of removal of fences, they have to present that to you further, an amendment to the plan?
I would just ask that in the motion, if the commission feels inclined to approve removal of the fence on the south portion of the property, that they just include that as part of the approval so that the applicant can move forward with that. And then in terms of the tree, just to help in terms of enforcement perhaps, the applicant could potentially engage an arborist, and as part of the motion, perhaps you could just ask that that report be submitted to staff with identification of any unhealthy or diseased trees, perhaps. Just a suggestion.
Way to make a motion? Okay. I move to approve with conditions the request to construct a rear addition and detached garage, perform exterior alterations, site improvements, and landscaping at 708 Market Street. Details as shown on the drawings, plans, photographs, submittals, and narrative statement contained in the application and supplemental materials, and statements made at this meeting are part of this request unless otherwise noted. This motion is based on the evidence presented before us, the application submittals, testimony, staff report, including the findings of fact. The following conditions shall be applied to ensure compliance with the design standards, those set forth in the staff report 1 through 6, as well as the following additional conditions. Review by an arborist of the condition of the trees on the property and removal of diseased trees with a report to staff to ensure compliance. And if removal of a fence is included in the plan, that supplemental information will be submitted to be included in this application to clarify the condition, what's going to happen with the fence. The proposed request with conditions complies with the Wilmington Design Standards for Historic Districts and Landmarks, applicable design standards 1.6, Secretary of the Interior Standards, Standards 2 and 9, 2.1 Landscaping, Standard 4, 2.3 Fences and Walls, Standards 3 through 5 and 9, 2.4 Walkways, Driveways, and Off-Street Parking, Standards 4, 6, and 7, 2.5 Garages, Carriage Houses, Accessory Structures, Standards 4 and 5, 3.2 Windows and Doors, Standards 1 and 6, 4.1 Additions, Standards 1, 2, and 4 through 6.
A second?
I'd just like to amend that if those trees need to be removed, they are replaced with new live oaks of at least 3-inch caliper. You're replacing 2 trees, so that'd be 4 trees replaced.
And should we specify the south side fence? Ivy mentioned wanting the south side chain link to be included also.
Yes, if removal of the south side chain link fence.
Oh, you did address that in number 8, asking for supplemental information submitted to
Right.
clarify. So I will make a request that the applicant submit an updated site plan with those fences proposed for removal to be identified.
Okay, thank you. Okay, I think we got it all.
Does anyone want a second?
Second.
All in favor?
Aye.
Opposed? Motion carries. Thank you.
Can I make one comment after the fact? I know several people mentioned about the hardy plank siding on the addition that is approved and used in new construction, and that's considered new construction. So as long as I think we request the smooth side out, that is allowed. Is that correct?
That is correct, and the applicant did specify in the product information that it would be smooth side hardy plank.
I was just trying to let the neighbors know why we didn't even discuss that.
We had an after the fact off of Castle and I think 5th on that at some point, not 5th, 6th or 7th. And they had put a Hardy Plank garage on a, and it was an after the fact. Am I not crazy? Am I crazy? I mean, it was.
You're not crazy, but I don't know about that.
Good response.
There was a house on Fifth Street down by Castle where they put the textured side out on the garage.
Yes, that's correct. It was on.
Okay. They put it backwards or something? Is that what it was?
Yeah. They also had the corrugated metal roof, that same project, the same
Yes,
house.
yes.
Yeah.
And
Okay,
that was
gotcha.
not approved. Hey,
That's right.
over here. No, that was not approved by you all. It's gone to the Board of Adjustment. The Board of Adjustment upheld your decision, and so it's awaiting if they're going
Okay,
to
I'm
appeal
not
to court.
crazy, though.
You're
It
not
was-
crazy. It happened.
Okay.
But you definitely didn't approve it,
Okay.
and neither did the Board of Adjustment.
Okay.
Okay, well, thank you. Thanks for coming.
Okay.
Okay, so we're now going to move to voting for a chairman. So we're going to take nominations and then vote on all the nominations. Is there anything you want to add to that, Melissa?
No, ma'am.
Okay, I'll start out. I nominate Kathy Egan for chairman. Does anyone else want to mention and nominate
I
someone?
nominate Christopher Yermal.
Any others? Okay, all in favor, all voting for Kathy, please raise your hand. That's 4. Christopher?
Please raise them up high.
For Christopher? That's 4. We have a tie.
So we're at an impasse. Neither nomination passed. Do we want to reconsider?
Toss a coin. Whatever you're all. This is why you don't have even numbers on commissions and boards.
Exactly.
Joan, congratulations.
Can we not nominate Joan as?
I don't believe that Joan is interested in
excuse
being chairperson. As vice chair, she would serve in an interim capacity until January, which is when we have our regular elections. So whomever if anyone was voted as chair tonight, that person would only serve until January as well. And then it would be back to our regular election cycle.
And we're not adding a 9th person, right?
We are not, and in fact, we're going
The
to...
next one that goes off will be at 7. Okay.
Yes. The new land development code will set our number at 7.
So that then there'll be 7 people voting on that.
Yes.
Does someone cycle off by January? Is there a commissioner that?
I'm not sure. We think it's April. I'm not sure, though. I can check on the exact date that the next person will cycle off.
So we'll keep it 8 until the person cycles off, or will there have to be a reduction in January?
We'll keep it 8 until the next person cycles off, unless City Council makes another change. This is coming from the Appointments Committee. They make decisions about how we handle our boards and the appointments to the boards. Okay, so I guess we move on to the next item on the agenda. Mr. Smith, I believe that's your item, sir?
Yes, I do. I would like to present. I didn't know it would come from you. I thought the chair was going to bring it up, but may I speak now?
Yes, sir. I'm sorry. I was just trying to move us along.
I'm ready.
Wants to go home.
I would like to circle back and address the topic that I brought up at the end of our July meeting, which was the fact that in the new land development code, formally the language is going to come out of protecting properties outside of the district. I had a discussion with Christine. I was aware when I drafted my letter to you that it was currently not being enforced. And part of that language is in the first paragraph that says the path to protection from Wilmington properties that remain at risk now and certainly after the 2021 Land Development Code is voted on and adopted. It is my belief that as a commission we should be advocates for restoring the stay of demolition for National Register properties, individually listed or contributed resources outside of our local historic districts and overlay through enabling legislation action specific to Wilmington and New Hanover County. We have examples of 3 other municipalities that have gone that extra step to protect those, and that was done through local acts permitting them to enact demolition delay protection for historic properties listed in National Register and State Inventory of Historic Properties, regardless of the location within or outside of the local historic district. Again, that quote that I included, I'm not going to go through and readdress everything that I had in the letter. I presume everyone read that, but there is an example of the language that those states, those towns have adopted as an example. Local historic preservation commissions are on the front lines of preservation. Designation of local historic districts and landmarks provide the most comprehensive means of protecting historical resources from degradation and destruction, stronger than listings in the National Register of Historic Places and more widespread than private preservation efforts. Preservation in North Carolina is much enhanced by strong preservation commissions. Commissions are at the center of preservation action. Having said that, I do propose that, and I can read this, or we'll have some discussion. I did draft with, actually, Ivy was so helpful in the basic blueprint of this. I did make some changes or add a few things. But it's my desire that our commission be actively involved in preservation, which is covered and described under our powers and duties in General Statute 160D-942. There are 11 of them. The legislation, if we adopt this, will simply offer the site and property time for consideration to spare or save. Ultimately, if a property owner wishes to tear down the structure, they will in due time, due course. Even if one building or site is saved through this legislation, it will all be worth the time and effort to gain this specific legislation to New Hanover County. I'd be eager to hear some discussion about it, what people's thoughts are.
I have 2 legal concerns with it. First is, how many houses are involved that we're talking about? Do you know? Or how many landmarks?
I don't know that.
Christine, do you know that?
Combined total, there are 6,367 lots in our National Register districts. I don't have a number of how many are actually have buildings on them, but there are 6,367 lots.
So one of my concerns is due process. I mean, you just can't go imposing a restriction on people without having them buy in or vote on something, and the whole due process, which I would like to know what that entails, what that costs. Number 1. Number 2, legally, where does City Council have authority over the county? If these are properties that are in the county and not necessarily in Wilmington, does City Council have any authority to do anything about that?
No, City Council would not be able to deal with anything that's outside of city limits. So it would be limited to the city's jurisdiction. And so what this resolution would do is it would just move this request to the next level, which would be City Council. They would have the discussions about the impact on all the neighbors and all of the houses that were there before they chose to move it on to the next level. So there are many layers here. This is just the beginning step. This process would take probably more than a year. I had to actually talk with someone in my office about how this works because our commission does not normally move resolutions up to city council. But if this resolution passes, we would work with the chairperson and the city clerk, I believe, to get this onto city council's agenda as a presentation to city council. And that would give city council all of the information that they need to decide if they want to put this on their next legislative agenda, which they set once a year, and I believe it's during the fall that they set it. Then we would work with the legislative liaison, Tony McEwen, see if one of our local elected officials in Raleigh is willing to sponsor such a bill and go from there. So there are many, many steps to this process. This is only the beginning.
Has City Council been presented with this before, this issue at all?
I am not sure.
I don't believe that they've formally been presented with this. I know that Historic Wilmington Foundation, both before Ms. Rutledge left and now Travis Gilbert has also addressed the issue. So they have been made aware. I know Commissioner Smith also brought it up at a public hearing with council recently, but I am not aware of a formal presentation that has been made to them.
I just want to add something on the process, too. I spent 25 years working on this kind of legislation, and it's a minimum of 2 years to try to get a proposed bill through a legislative hearings and votes. And that follows usually a year worth of white papers, visiting legislative people, finding a sponsor, hoping there's not an election so your sponsor doesn't disappear in the middle of the night. And if you even get lucky enough to get your proposed bill dropped for a committee hearing, you have to tell that committee chairman who might oppose it so that they can be contacted to testify at the hearing while you're testifying. So I understand that this is, and I completely agree, it would be lovely to get these changes made, but I hope there are no expectations that this is something that's just going to sail right through because it's a good idea. It's a really long, drawn-out process.
No, I don't hold any false hope that this is going to be on a fast track. I know that it will be slow, but you know, it has successfully occurred, and as a preservation body, I think it's our duty to speak for this and start the process and see what our legislators will do in terms of making that commitment to preservation in this county, which has certainly been applauded by our mayor. When I went to the state preservation meeting that was held here, he offered the welcome and he sang the praises of preservation in Wilmington. This just seems to me another level of that commitment.
So based on Kathleen's comment then, I guess someone would be tasked as kind of an ad hoc off the commission, or did you say the chair would automatically do this? The chair of the Historic Preservation Commission would help shepherd this through, or what happens if this resolution were, say, to pass us tonight, then?
It's my understanding that the chair
This makes
would,
work for who?
I'm sorry?
This makes work for who at that point?
Well, Ms. Keston.
Oh, no.
I think typically when resolutions come from one board and go up to city council, it's the chairperson who presents to council and answers questions. I'm sure that if someone else felt more passionately about it and the commission agreed, that person could do the job instead, especially since we lack a chair right now. And Commissioner Egan, you know much more than I on this subject, but I think once it gets to city council, if it goes onto their legislative agenda, I don't think the Historic Preservation Commission would be involved in moving it along. I think that would be with our legislative liaison, who does that as that's his full-time job, I think. That's my understanding. Like I said, we don't do this very often.
I was going to ask if this is approved, this resolution, that there be a committee formed of 2 or 3 people that want to be part of following this and being available to individuals who have questions, you know, whether it be city council or anyone that really just is on track to follow the progress of, or lack thereof, of this.
That's going to be almost necessary because we wind up being subject matter experts because we live here and have to deal with this. Whereas our legislative liaison and the proposers, I mean, when you get in front of those committee hearings, you'll sit there for 2 or 3 hours and listen to proposed legislation for everything from horse and carriage trade on up. And so you have to have subject matter experts who can then speak to whatever it is our concerns are. So even if we have the legislative person, he can't do this himself because he doesn't know really the nitty-gritty that we do, because we see it all the time with applications and we see it within the county, and you have to work with it. So this is the subject matter expert that the legislators will expect to hear from, because they're not prepared and they don't want to get in that committee room and get blindsided.
Right. Well, my suggestion of a committee was just in the infancy of it, not for that body or that committee to be carried right through. I appreciate the information you're imparting, having served in that capacity and dealt with that, but I'd hate for us to have a pessimistic attitude about can this get done and how long it's going to take to get done. I think that the preservation of sites and buildings is, you know, far exceeds that effort that it takes.
And with that person that helps in the initial steps, the very initial stages of this, just between commission and city council, does that person, and maybe helping beyond that, does that person need to be on the Historic Preservation Commission?
Well, I think that at least someone from the Historic Preservation Commission would need to be involved in the presentation to City Council, yes, so that they could speak to the commission's vote and deliberations and that sort of thing. But if you got outside help from the Historic Wilmington Foundation or someone like that, I mean, that's an interested party that would be able to share their expertise, and I think council would be interested in hearing that perspective as well.
So the negative of say bringing this up for a vote right now and it passing, what is the negative? What is the? I'm curious. What does that mean? Why would we not vote for that? In case someone were to say, I don't want to vote for that, what would that reason be? To try to get this to City Council at least. And I would just say that I would vote for it, but I can't take the time out of my career and my life to do anything with it.
It's fair to say that, you know, it does need to be someone who's passionate. I got it this far. I would happy to hand it over to someone if they feel the same passion and fire for this. If they don't, it's going to be hard to communicate that to City Council or to any other body or group. And again, this is only the first step, and it will ultimately be up to City Council if they wish to pursue this line. But I'm absolutely with you in that I can't imagine why, as a preservation body, duly elected to oversee not only COAs every month, but through enabling that legislation, lots of other areas that have never really been harnessed by the Commission. And this is but one of them. And I think to speak up and be an advocate, it's really in our preservation's really in our title as a commissioner. And I would hope that this is something that we could support.
So if we were to vote and approve this, we would just be hoping that someone could pick it up and do some lobbying, for lack of a better word, of city council and try to help get it on up through legislative channels up to the state.
Mike, would you be
Well,
willing to present?
Yeah, I certainly would be willing to do that. And I think, as Melissa said, it would just go up and get on their agenda for discussion, and I certainly would not mind going to City Council and laying out the same presentation I did to all of you.
Wow.
And talk about the merits of preservation. And certainly, you know, I have not asked staff if they keep a list of properties, endangered properties, or significant properties. During the interim between, if we pass this and it goes down the avenue of trying to get this legislation passed, we may well need as a body to compile a list and just put that under an umbrella, because there is protection, but they must be listed individually before the fact of demolition. And the hardship on the homeowner, getting back to Ms. Keston's question, is it really is just asking the homeowner to have a second look. And with the development that's going on in our city, that we have some ability to put development in terms of bulldozing a site or a structure, building, and give pause to try to work with the homeowner, or I mean the property owner, and work out a solution to move the property, to talk about tax credits, can they incorporate it in their design plan. That's all this will do, even on a state level. Ultimately, if the property owner wants to get rid of the significant site, they can in 365 days.
If this were to pass logistically, would this fall under staff to handle all of this, or is that, we're talking a whole different level of employment? Or, I mean, because if you're bringing in a certain number of additional properties, that requires more work in terms of enforcement and checking on things. That's all involved in this, I would take it.
Right, that's correct. And I don't know what length of stay would be proposed. When previously the stay for the National Register was 90 days. In the local districts, obviously, it's 365 days. Well over half of the demolitions that in the past 5 years in the National Register District, those applicants never came before the Preservation Commission. They just filed their notice of intent to demolish and waited out the stay. If you were to seek a stay of 1 year, that's obviously a much longer period. So that would obviously add to whatever case reports are being produced, applications are being reviewed, the board is reviewing, and then it puts the onus on the Preservation Commission to then take action. If you do not waive the stay, you are then obligated to take some action to try to save the building. So it would be a staff effort on the front end and a commission effort once the application, once the stay would be upheld.
Michael, I didn't get whatever you sent around, so can you send that to me, please?
Say again?
I didn't get whatever you sent around, so could you just send that to me, please?
Oh, you didn't get it? I'm sorry. I'm very sorry.
That's okay. I mean,
I will. I
Okay.
certainly will. I'd be happy to show you the resolution if you'd like to review it, or this letter now.
I guess I don't have a problem with the resolution to City Council, because it's really, you're just putting it in their lap to decide what to do. I just tend to be shy of recommending something when I don't understand the full parameters of it, the full cost of something, and what's all involved. And that would be my only hesitation, is that I feel uncomfortable doing that. If it's just in the sense of, you know, as a commission, we want you to look into this kind of thing, I'm kind of okay with that. But without understanding, you know, the amount of additional work, the amount of additional costs, all what's involved, I have a hard time really proposing that somebody do something without understanding it. That would be my hesitation.
But is this any different than what we have been doing all along and found out we really shouldn't be doing? I mean, am I crazy?
What?
We've always had 90-day stays of demolition in the National Register District. Somewhere along the way, it's filtered down that, gee, we weren't supposed to be doing that all this time.
Well,
So this, with this,
this is outside of that, yeah.
well, Melissa's already said that outside of the city, we can't do anything.
Correct.
Right.
Just talking about within the city limits of Wilmington, for
So-
sure, right.
Well,
What is different than what we've done all these years?
Right. I mean, we would, if we wanted anything more, we would have to go to the county commissioners.
Right.
I mean, and this is what the white papers are for, is to explain to them what we want, how much it's going to cost, what the logistics are. You have to give that to them on a silver platter, or you're going to get nowhere. So we have to be really specific about what we're asking them, especially if we're asking them to back us on what we want. They want to know exactly what that is before they say yes, which is only fair. So yes, we have been enforcing what we thought was right here as far as the standards go.
Right.
But if that's going to change and we lose the right to do that, then this becomes more critical. And quite frankly,
Well,
if the
I
county
see.
doesn't have protection either, then
I mean, I see Michael's point of if it's, yeah, if we've been doing it and weren't supposed to be doing it, and now we need to try to propose something to reenact that. Yeah.
Well, again,
In the name
I
of
think that, an endorsement of this would unfold. I mean, we would learn what you're talking about if the county needs to get involved, look to them beyond just city council. But I don't see that as insurmountable, and I don't really understand, given the language example that I gave and the resolution, that the commission would adopt what is not understood. I guess what the fear of approving something that you don't understand.
Do you know what the
Michael,
due process is? Do you know how much that's going to cost? Do you know how many houses are involved? That's what I mean. I don't mean that I understand what you wrote, but to understand, to get a full sense of what we're asking is, and I'm not saying I'm against this at all. I hesitate to endorse something when I don't know what the total extent of it and cost is.
What has it been costing all these years we've been doing?
But the process of what we have to do now is a whole different story than what we were doing before. A process of getting it approved is what I'm talking about.
Okay.
Not that the eventuality of doing the same thing. It's just that there's a huge process to be able to go do it now the right way.
So I think what Joan's asking is, tell me if I'm wrong, obviously, but there needs to be like a white paper for the next step. Let's just say, for argument's sake, that this were to be approved by us and we sign off on this and this goes to the city. I think before we'd even want to do that, it'd be nice to know what the ramifications are, money, the surveys, and some more information on who can help with those initial processes. I mean, Michael, what you've done is a lot of work, and it's super, but I think just hearing about like the next step so everyone's aware, and even staff is aware of what would be required, that we would understand that and then can vote on something like this at that point, just to have a better, fuller understanding of what we're really voting on, potentially, with getting this to the council. Like, I'd hate to vote on it, and then it goes to council, and it's just impossible. It'd be nice to know what else is involved, by whom, and for how long, and what it would take to get things done to actually make sure that this could get to the state. The state says, yeah, you can do that, but then,
Well, yeah.
yeah, but then, and then that would have to go into council's
Unless
budget.
we
They'd
have a
have to probably
management
hire
and budget
additional
office
people.
somewhere in this commission, I don't know how we're going to come up with the data for the cost and all that we're talking about here. I have no idea how to go about that. Yeah.
Our purview, I mean, to worry about that, I don't know. I mean, I'm just asking with what Michael is asking the commissioners to do. I'm not sure if approving this resolution to send it on to council involves us dealing with how it might be implemented and the cost of that implementation. I mean, that's the city council or whoever does that type of stuff.
But
agree with that.
Well, I have to say, too, related not only to this subject, but I appreciate the concern of the time and energy by staff and what the money, things cost, but I also am very clear on the enabling legislation that provides guidelines for commissioners, whether it's asking for a review to look at expanding the boundaries. All of that is under our discretion to propose and ask staff to look at it. And there's a cost analysis. Again, City Council is going to be the final say in that. But, you know, if we don't move forward in some way, worried about manpower and hours and the cost, then we just are a body to just approve COAs every month. And we are not embracing the 11 powers that we have from general statutes from North Carolina.
I understand that, but I've heard that for the term that if it doesn't go on a silver platter to council, I mean, if the numbers aren't there, they're just going to look at it, this is nice. I mean, if it goes to council, I wanted to have a shot at success.
Well, I think that will happen before they take it up for consideration, but we don't have those numbers now, and you know, I would not want to embarrass them, but again, I think if one or two good properties down the road are saved as a result of this legislation, then it's been worth it.
I understand all that.
Yeah.
I certainly don't see any harm in us approving this and sending it to council and then see what they do with it.
And with a little lobbying of city council wouldn't hurt, but yeah, I understand that.
Is there anybody that
Is your resolution real long? Do you mind just reading it real fast? I don't even know what it says.
the resolution?
Just what it is you want us to vote on. It's long.
Did you send that out, Michael, or not? The resolution?
Yeah, that's okay.
Right.
Yeah, they were included in the attachment.
If city council were to require a lot of study on this, would that fall back on you guys to do? And I imagine that you have plenty of time to do that?
I don't know if we're worried. I mean, if we make a resolution that we have to be concerned about who's going to do the workload, I mean, I feel like that's not our purview. I mean, we're here to save historic buildings and, you know, try to work with people who own them. And I think city council and the city manager, they're going to have to be the ones to determine, can this be taken on, as opposed to us worrying about, are we going to overwork the staff folks? I just don't feel like that's part of what Michael is trying to convey in his message here, but
I just will say, you know, obviously staff can't weigh in on it to say, you know, so it's up to us. I mean, you know, they will do the research and we know the protocol of how it will move, but, you know, we have preservationists on staff with the city and they oversee us, but they can't weigh in and push for this. It really is up to us or it just dies.
The only thing that's missing that I would have added to your resolution is whereas the development within New Hanover County or Wilmington is going so fast that we feel these houses are in danger. Because we can't even say to them, we've lost 5 of them this year, or we've lost 2 of them. You have to be able to convince them that there is an imminent danger to the community And that's why we're in front of them asking for this.
I
And
agree,
that's
Kathleen,
missing
with
from what you're saying.
and I think this is just the first step. The presentation to them, which is going to be much more significant than our endorsement for this, will need to have more facts and numbers. I don't think that we know, based on other cities that have done this and the legislation that was adopted specifically to their area, how that reads. I think there's more to come from this in terms of research before council's willing to embrace it.
No, I agree with you. I just think that we have to somehow separate this from like, why has nothing been done or said before this? And we have to say there's so much development now.
Well, I would wonder that also. I was completely unaware of this until some of the land development codes started coming out, some of that information, and it was just so black and white. And I was never informed by our previous preservationist. Anyway, it's rarely, it never was presented to me or to commission that this was not being enforced and that it was going away formally in the language in the new LDC.
I would say that in one of your paragraphs. That,
To highlight the
it's come to our
development pressure.
attention now.
Well, I have a copy of it. I think it was from Melissa that just highlighting some of the changes. I have a copy of that here.
Oh, pardon me. I agree with Kathleen, like rereading this now and not seeing anything about that, and just at least highlighting that we all know that the development pressure on these historic structures is significant. I mean, there's a case where there's allegedly right now a very, very old house off of Greenville Loop Road that's the owner's moving forward with trying to demolish it, and some neighbors are kind of beginning to try to create a little bit of a small group or a committee just to talk to that neighbor and highlight other options. But it's the house, the primary part of the house was built in the 1860s or 1870s or 1880s, something like that, and it's the new owner wants to. They're kind of being. It's being suggested to the owner that really should just be demolished by the contractor, and so I mean these things are happening, around these things are being lost. So with that, I mean maybe just to have some support from Kathleen to maybe just look at this again and think about adding a whereas for something like that, and then bring it back. And do you feel like it would be too late to vote on something like this next month?
Early on in there, it did say about.
And are those the only other two cities in North Carolina that you know of, Apex and Cary, that you listed here?
I think that could easily be added, in addition to what we have here. I hear what you're saying, to hold up an adoption of this for just one more whereas, just really addressing the fact that with the rapid development, that is the concern. I would, in putting this together and presenting it to you all, I in no way feel that this is a renegade item that I'm bringing forward. Other cities have done it. The examples of that legislation is there. I haven't called anyone who led that fight, but I am we'll see if there is support or a vote for it, but I'm disappointed that, as a preservation body, that we can't eagerly get behind this and just move it to the next level, but that's up to everyone here.
I know there's the first thing you say is about the significant concentrations of urban 19th century architecture. I know for a fact that there is a developer from out of town that purchases properties in Wilmington and redevelops them, does adaptive reuse, and invests millions and millions and millions of dollars in Wilmington. He comes here because there is no what he calls stock in other parts of North Carolina, like there is in Wilmington. I mean, he's made purchases in areas in Wilmington that are not in the historic district, but they're classic old buildings, and he does stuff with them, which doesn't allow him to get the tax credits for them, but he still likes these old buildings and does this stuff down here because we have, and what it does for the local economy is significant. It supports a lot of jobs, and he comes here and does it in Wilmington because we have those properties that other places don't, and as they keep getting chipped away at, they go away forever, and then you have instances like that where you're going to have someone that the stock isn't in Wilmington anymore, and so.
Well, I agree with you, Chris, and I think preservation has always been sort of Samson and Goliath. You're just, somebody's a big developer, big money, and that sort of thing, and preservation are just saying, try to save this building, try to save the building, but at the end of the day, I want to be in that seat. I'm obviously not the developer, but all we're trying to do in this is to work with the developer and say, can this house be moved? Can this building be incorporated in your design plan? That's all this legislation will do. If the developer is destined to take the building down, they will in time. And
Can we vote on this resolution with, accept it today with just the fact that Kathy might add a particular whereas clause so that you don't have to wait another month?
Sure.
We could do that,
I think
then
that,
we'd satisfy, a couple of.
yeah, I'm not excluding your comment. I think that, that
We'll
to
avoid the issue of
offer
waiting
that,
for another month, but
I
have
think
those
before it
subject to that.
really moves up, it certainly could be, more could be added to it.
Yeah, but I'm saying we could say what it
Correct.
would be and then approve it, and then you're good to go.
Right.
For right now, you're willing to add Kathleen's additional whereas, additional clause.
Right.
And,
Talking about development.
right, talking about the development, the rapid development, so.
And then the other comment you had about referring to, not only about the rapid development, you were referring to something else in code, about the code was eliminated or something. Yeah.
Well, again, part of this, if it had gone through.
I'm sorry,
does go
can y'all
through, that we would
please
sit
speak
to
into your
form a committee.
microphones? I'm sorry, can you please speak into your microphones? I'm still having to record, and we can't hear you if you're not using your microphones.
Okay, so, Michael,
Training on microphone use.
We're thinking of approving his resolution with, subject to a couple of additional whereas clauses, which will stay what they are, and then it's done. We
right,
don't have
and
to
then
wait a month.
then I can help you clean it
Well,
up
I
and
think
go.
to your last point, Kathleen, was that from a small committee that could work on this language and, address that rather than trying to get 8 people to do it. I mean, the point you've made could certainly be incorporated.
Yeah, so we can approve
It is a
tonight to do
committee
that.
that is aware of the direction and where things are and that sort of thing. Not that, I certainly don't mind doing it, but, there are 8 people. If someone would like to join in, be part of this, I'd love it.
Chris said something that perked my interest too. So if this went through, then there would be more properties that could receive the tax credits, the federal and the state, or no, it wouldn't make any difference?
Well, I would think they would need designation to get those tax credits, but it is frequent, I list in the presentation reasons for stay of demolition, and certainly one is to encourage the property owner to look at, federal or state tax credits, but it would have to be some designation.
I'm just trying to think of positives.
And if the district couldn't ever grow, if there's nothing to grow and absorb, if the historic properties where the historic district would move to, or if those properties are gone at some point, and we keep losing them. So does it seem like we're going to vote on this or wait on till a little bit more language is added? Can it wait a month, or I don't know?
No, I think we vote on it today, subject to the addition, and Kathy could work with you easily, don't need anybody else, and just approve it today, subject to the addition of the
just
content
agree in
of those
theory to
two
that.
whereas clauses,
Yep.
and we're done.
Okay.
And I think Kathy and you working on it could just be fine.
I mean, I'm
Wouldn't take
happy,
long.
I'm sorry, Kathleen, you didn't get it. It didn't bounce back. I'm sorry that.
It wouldn't take long.
But I did, but I'm happy to read this if you don't have it in front of you or with you into the record if you want. It's that. Resolution encourages the City Council to pursue special legislation for stays of demolition for historic buildings outside of local historic districts. Whereas Wilmington has a rich architectural and cultural heritage worthy of preservation, and whereas Wilmington has one of the largest and most significant concentration of urban 19th century architecture in the state of North Carolina, and to a lesser extent, but significant, 20th century, mid-century modern architecture, and whereas Wilmington's commercial and residential buildings reflect the economic and social vitality of what was once the largest city in North Carolina and continues to serve as the state's largest port and most urban coastal city, and whereas Wilmington has been a leader in historical preservation efforts in North Carolina to protect its unique heritage, which can be found in the display of architecture from nearly every period in its history. And whereas since 1962, Wilmington has had a local body established to aid in city preservation efforts. First, the Board of Architectural Review, which became the Historic District Commission in 1970. And in 1999, it became known as Historic Preservation Commission. And whereas the City of Wilmington currently has 8 National Registered Historic Districts, those listed: Wilmington, Carolina Heights, Carolina Place, Westbrook Ardmore, Sunset Park, Market Street Mansion, Brookwood, and Mason-Burr Sound. And whereas the City of Wilmington became a certified local government in 1986, a recognition by the federal government of its commitment to carrying out preservation efforts to save its irreplaceable historic and cultural resources. And whereas the state of North Carolina does not specifically enable stays of demolition outside of locally designated historic districts, overlays, local landmarks, and those under official recommendations for such. And whereas the purpose of stay of demolition is to afford the opportunity for preservation commissions and preservation advocates a period of time in which to work with property owners seeking other alternatives to demolition, such as educating the property owner of possible tax credits available, moving the structure, or salvage. And whereas other cities in North Carolina, Apex, Cary, have special enabling legislation authorizing stays of demolition for properties listed on the National Register of Historic Places, but outside of locally designated historic districts, overlays, and local landmarks, and the Historic Preservation Commission desires the same for our city. Now, therefore, let it be resolved that Wilmington Historic Preservation Commission encourages the Wilmington City Council to pursue special legislation from the state of North Carolina to enable the city to stipulate a stay of demolition for properties listed on the National Register of Historic Places, but outside of local designated historic districts, overlays, and local landmarks as part of our continued effort to protect and celebrate our heritage. Protect our heritage, use our historic assets for economic development and community revitalization, and encourage people to experience and appreciate local historic resources through heritage tourism.
Aye.
Can you add Kathleen?
And then we would have, there would be, before that closing, whereas, talk about development and put some language in there related to that. And was there one other item that you had a second one? Right.
And then the
Rapid increase of development.
Okay.
and this proposed change in the code, or was that already in there?
And potential change in code.
Say that last one again. I didn't hear you.
Changing code.
Potential change in code.
Okay.
I would add that would, diminish our ability to protect the homes.
So highlighting some of the imminent threats, to make it clear. In those two
I didn't
forms.
understand you between the thing. Say it again.
To highlight some of the imminent threats, the change to the land development code and the development pressures that this region is kind of
Well,
experiencing.
it would ultimately, again, from, as dictated from the state, I mean, it would be the protection that would, sort of like a general statute, from the state that would offer the protection to those properties outside. And it still would be a good idea, even with this legislation, for there to be a master list kept by, the city or in partnership with Historic Wilmington, that properties at risk be identified. And I know for years Historic Wilmington has kept such a list and publicly talked about properties or sites that were at risk, and that probably needs some attention.
Well, hopefully, council would fund means to do that, and they should.
Hope so.
Is there anything keeping us from going to the county for this too, or not?
I don't know that there's anything keeping you from going to the county. I don't have any idea if they have any sort of historic preservation program in the county. I'm not sure if other members of staff know.
Start with the city.
So do we want to vote on this then?
Does somebody want to?
Yeah, so can we
Yeah,
vote on
yep.
it? Can we just vote
Fine
to
making
approve
it if someone will second it. I mean, I obviously presented it, but I make a motion that we adopt this resolution to start the process, having read out the resolution publicly, adding 2 more items to the list, that as a commission, we adopt this and support it.
I'll second it.
All in favor?
Aye.
Aye.
Opposed? Passes unanimously.
Thank you. Thank you, commissioners.
Thank you for your work, Michael.
I'll sponsor the bottle of rosé when you guys get together on that.
Meeting adjourned?
Are we officially adjourned now?
Okay, all right.
Madam Chairman?
The meeting's hereby adjourned.